serial number 65. It has been delisted, madam. Let it come tomorrow or day after tomorrow. At your convenience, madam.
It may not be possible. You give it, we'll see. In what is the urgency? What is the urgency?
Urgency, my lord, the petitioner is 20 years old. And he is in custody since 23.
It's a bail matter.
Bail matter.
A bail matter. Bail matter. It's all right. Bail matter.
Tomorrow.
Not tomorrow. Friday, maybe. Maybe Friday. Okay. Yes. Any mentioning?
May I please, Your Lordship? Your Lordship has specifically granted that it will be listed on 23rd of this month. But unfortunately, it is coming in the list that it will come on the next year, 24th. So I'm in the out of job and I'm without pension. And it's 7 years already there.
Is this a miscellaneous matter or
No, hearing meter, everything is completed and Your Lordship had also sometime and Mr. Das.
That's
also,
right. You must be seeing that. See, the miscellaneous matters are not getting over.
I
100.
understand. I understand. We'll take only 15 minutes time, Mr. Das and.
What do you want? What do you want?
23rd it will be listed. Your Lordship, what Your Lordship directed.
23rd again. You try. I don't know what happened. 23rd. Okay.
Deeply obliged. Deeply.
Oh, it's already. Oh, there is already. It has already been adjourned. You have to move an application then.
No. Your Lordship had directed that day. It was listed on.
No. You tell me.
Item 1.
Is it in the weekly list?
Your Lordship, it was in the weekly list, Your Lordship. And
Yes,
my Lordship
yes.
said the matter to be listed on 23rd or 24th of this month. But the matter has been adjourned to January 2025. 24th of January 2025.
But then you have to move an application. I can't modify the order like this. Move an application and mention it. I'll do it. We move today.
Oh, please, Your Lordship. Please, Your Lordship.
Your Lordship, last month, Your Honor had passed order in a 205 case that if I file the medical certificates of the accused to get a personal exempt, I have filed that it is again rejected for one of it. So I have filed it as CRLMP 4752, Your Honor.
You give a memo. I'll see. I'll just.
I have already filed yesterday, Your Honor.
Yesterday.
Yes,
See.
Your Honor.
What is the number?
4752 CRLMC.
47. Just check it out.
4752.
Let's just check. Okay. See.
Yes.
Yes, madam.
So, Lordship, item number 20, Lordship, kindly have listed it after accusation.
20. What do you want? Adjournment. Okay. Bail matter. Okay. Adjournment. Okay. Yes. Yes.
Item 1 to 7.
Item number 7, my lord. In this case, on the last level, she was pleased to direct me to obtain instruction regarding trial. I have 1 week time may be given. I am not
on request adjournment. Obliged. 1 week. It may go to February. Okay.
Serial number 1. Your Lordship was pleased to adjourn the matter on the ground that the conducting counsel was going through radiation. This matter was fixed. Today is the last round of radiation. Is in Tata Memorial.
Okay. Then what do you want?
We commence
First week. First week. Okay.
My lord, item 6, my lord.
Second week.
My lord, item 6, my lord. I pray for an adjournment, my lord.
Adjourned.
After vacation.
Item 2, Your Lordship. I pray for an adjournment.
12.
Item 2, Your Lordship. Adjournment.
2 also.
Yes, Your Lordship. We are filing an additional.
Item 4.
Possibility.
What is happening? Why everybody is asking for adjournment? I don't know. Anyway, vacation mode. It's all right. No problem. Okay. But all these matters, those who are asking for adjournment, will go to February. I can't adjust the date like this. Okay. February. Let it go to February. Okay. What do you want? What do you want? Tell me. Give the memo. Give the memo. Yes. Not tomorrow. Not it. Weekly. Yes. 8 to
17. That's item. May I be pardoned? That's item 14. On behalf of Mr. Sangram Das, he is having some personal difficulty today. Any other day, madam?
Okay. Sangram Das.
14, 79 and 80.
14, 79 and 80.
Yes, madam. So grateful, madam. 79 and 80.
Yes.
Grateful.
Yes.
18 to 22.
23, 24 to 28, 29 to 32.
Your Lordship's item number 29. Your Lordship was pleased to direct me to take instruction with regard to co-accused bail. Your Lordship, they have filed, it's posted to January. Your Lordship may take it along with and supply the numbers.
Okay.
After which,
Give that.
I'll supply your Lordship after which.
Yes. Yes. 33 to 39. 40 to 46.
52, I have already filed a memo for withdrawal.
Yes, withdraw 42, withdraw, yes. Yes. 47 to 51.
My lord, I'm mentioning, my lord, CRLMC 4708, my lord.
Which item? Which item?
It was directed to be listed, or today there was a judicial order passed. The matter has not been listed. And all of us, my lordship will remember, this relates to those private equity funds. The whole idea was to take everything up together. Somehow it has not come, my lord. Kindly take it up tomorrow, because the other matters are
sorry, 49 and 50.
we were seeking interim protection in that matter.
49 and 50, we are here, my lords. We'll be here to assist. 49 and 50, I'm here.
49, 50.
They are
49, 50.
Yes.
Our matter was directed to be listed today. It has not come.
Because my learned
Mr.
friend,
Mishra is online, we'll join. When the matter is called out, we'll join.
because my learned friend has a different matter. I'm in 49 and 50. When lordships takes up 49 and 50, they can get them.
The same PS matter.
The issue is almost same.
Yeah, that's the issue, my lord.
Okay, it's all right.
It should have come in the list. There was a judicial order.
Why it is not come? If there is a specific direction.
Yes, there is a specific direction.
Why this is happening?
Can I just remind?
Yes. I am wondering if there is a judicial order to be tagged with this matter, why it's not coming?
It's very surprising.
No, I just want my office if they are correctly doing things or not.
Please,
Yes.
I'm not
It's
down
the
there.
internal matter, my
Just
lord.
verify and tell me, 12 o'clock. Ask you to verify and tell me. If there is a judicial order, it has to be listed. Yes.
It may kindly be taken up together, my lord.
Okay, I'll take it up.
Yes,
No
Mr.
problem.
Luthra will join, my lord.
But the issue is same, let us
Same
understand.
issue, same issue.
That's right. The
Mr. Agarwal is there.
same FIR.
The matter has not tagged with, my lord.
That's all right. When the matter will be taken up, because the documents are almost same.
That's right.
Same FIR and everything.
That's right.
I can hear you also.
Yes.
That matter may
I
not be
bow
there.
down.
I
I
can
bow
hear
down.
you that.
I bow.
Is it in the special?
I thought I suggested something.
Yes.
Directed the CP for that.
Is there any, something is happening?
That there was a proposal submitted that you will come back with a specific mode of solution of the problem.
Have you submitted any?
That they are supposed to come. The proposal was their mode of settlement. But today I was just telling the lordships in that matter is not coming released by a special notice that can come along with it.
Yes, yes, sir. That's right. By a special
I
notice.
was just trying to tell the lordships in that matter escape the list.
Hmm.
But that by virtue of a special notice that matter can come and. Yes.
I'm obliged.
That's what.
Then I'll take it up at 2 o'clock.
Yes, yes.
Taking all the matters by that time it is.
2 o'clock, I have a assigned matter in Honorable Chief Justice.
Then what do you want?
Let it be 3:30 any
Okay,
time.
3 o'clock.
3 o'clock.
3 o'clock.
As your lordship.
So you people can relax.
But no relaxation for us.
Special notice, huh?
No
But
relaxation for us.
still Mr. Agarwal is there.
Yes.
If you can work it out, why don't you work
But
it out?
I don't mind working
See,
it out.
it is all commercial transactions.
They have not given any proposal. Because may I indicate, I don't mind. I don't mind working it out.
Hey,
May I indicate one?
are you giving some proposal to settle
May
this?
I suggest one? This is a scenario, because your lordships have broadly heard us. Otherwise, your lordships will hear us today if we are not able to resolve it.
Yes.
But like all commercial disputes, ultimately, my lords, it has to meet
And give and take, nothing else.
economic death,
Yes.
one way or the other. But I have, while I was not here when your lordships actually made that indication in Mr. Luthra's matter, that information was given to us. There are two issues, my lords, which I placed to your lordship's consideration. This matter, my lords, has multiple persons, some of whom are before your lordships, some of whom are not. Because what is happening is, and I don't want to get into any kind of allegation or counter allegation, there was a previous proceeding. There was a settlement with some people. The proceedings were withdrawn. Now some others we will settle. This issue will never finish. So if there is any issue of a amicable or out of court settlement,
That is what is.
it must obviously entail everybody's presence. That is one. But otherwise, because I had one subject to what the other side says. We are proposing, they claim that they are owed some money. I say that you are not owed some money. We are fighting that fight and an investigating officer is to decide.
Yes.
It would be in the fitness of things. If we can agree to even this much, that we will place this into a time-bound arbitration. Everything is documented.
Then you can work it out.
Decide.
You can work it out.
That means own money. We will pay
So
them.
you work it out and tell me 3 o'clock, we will find out.
Otherwise, if we are
We
not
can,
able to-
if you want, we can appoint someone, some arbitrator or
That's right.
some. See, ultimately, the criminal case will lead you nowhere.
That's right. That's right.
See, ultimately, these are the commercial transactions. You can
I have to assume that their grievance from their point of view is genuine.
think over. If he agrees, then we
Do
can
that.
proceed.
Otherwise, your lordships may.
Otherwise,
interrupt me.
hear it.
I bow. Right, Lord. Your lordship
Just
will
wait.
on merits. I bow.
But you just, Mr. Ratha, you just also think over. You
Definitely,
put it to
I'll tell my
your, put it to your
client-
clients. It is a better
But
proposition.
today, as I have understood, the proposal is matter will be referred to arbitration and matter will be resolved through arbitration and nothing is, they are not proposing to pay any amount at this point of time. That's the proposal.
No, that he hasn't said. He
That-
may
that is
pay
the
also
proposal.
to begin with.
Whole
So bona fide, he'll pay you something.
Admitted payment.
You need litigation expenses also.
No,
arbitration
they are
expenses.
referring the whole issue till arbitration. That is what I have.
Anyway, you
I'll
want,
talk to the client.
we'll
That
see.
is-
I bow.
We'll see. Yes.
I bow.
Yes.
More
Let me complete.
I would
the-
have been you.
Yes. Give the number, we will be. Special notice ले आओ. Yes, ठीक है.
57 on behalf of Madam Jena, may kindly be taken off first week of January.
Yes, adjourned, 57 adjourned. Yes. 56 also.
57 there is interim order to continue.
Oh, 56, 2012 matter.
57 2016.
57, 2016 matter.
See, has some personal difficulties with it.
First week.
74 also.
Yes. See, 56. 56 is 2012 matter, sir. You are enjoying stay. Why adjournment? I'll see that. Personal difficulty, I know, but there is a function in their family. That may be the reason. But what happened to you? I'll see. Otherwise I'll accommodate you, but I'll not give a longer date. Okay. 56 mark कर लो. ठीक है.
Lordship, item number 61 on behalf of my senior Mr. Devi Prasad Dal, senior.
61.
I'm praying for him.
Okay.
Lordship, interim order is also there.
61 na 64. 61. 64 is also.
64 is also our matter, Lordship, that also I'm praying for an urgent. 61 and
61 and 64 कर दे.
60 also.
Lordship,
60 also. I think I will be free today.
60 miler, kindly fix a date miler.
60 also.
Lordship, in both 61 and 64.
Obviously, date will be fixed. Why do you
Interim
go?
order
Yes.
is there, Lordship. That's full.
62 to 66. 67 to 75.
74 my lord. On behalf of Madam Jena, may kindly.
74?
Yes, ma'am.
Okay.
Okay.
76 ଟା ଆଜି ପାଇଁ ଥିଲା can it be taken up on Monday କାରଣ short ଖାଲି short instruction ଦରକାର এটা ହବ କି ହବ ଆଲା ହବ କି ନାହିଁ ସେଠି
Monday.
76 ହଁ
But
Monday
let him come. I'll do it, but let him come.
ସେଟା ସେ cover ହବ କି ନାହିଁ your lordship
Covered over there. Yes. I know. Okay. Doctor, tick mark ରଖିଥା, tick mark ରଖିଥା, ଦେଖିଥା. Yes.
77 to 81.
Yes.
Pardon to mention my lord.
Yes.
In the criminal case, my lord, during pendency of the case, the warrant has been issued. In this case, you will also already issue the notice to the informer, others the states. And also he is a government servant. He will arrest him, lose his job. That is the last of it, my memo was also, but he has not been listed.
What have you filed?
I filed missives for the stay of warrant.
Stay of warrant.
Yes.
It's
He is a government servant, he will arrest.
a cancellation of NDPS only, in true sense.
Yes.
All cancellation of NDPS.
So, pardon me to mention, Lordship.
Hmm.
The criminal miscase matter arising out of a DV case, Lordship. The maintenance has been awarded without the marriage being proved. So, the execution case has been filed.
Maintenance, what is the maintenance amount?
The maintenance, Your Lordship, has been granted for a monthly 10,000.
10,000 is very less.
The thing is that, Your Lordship, the marriage has not been proved.
It's all right. First week of January, first week. Immediately.
Much less.
May I be part? My lord, the 205 application of the petition has been rejected, my lord, and the date of appearance has been fixed to 24th of this
What is
month.
rejected?
The application under section 205 of the CRPC. my lord. And the date of appearance is fixed at.
It's all right. One day you appear.
My lord,
You move 317 one day.
My lord,
Then I'll take it up.
my lord, the difficulty is the cognizance has not been taken in that case against me, and yet someone was issued, and there is
Then that's more of a reason 317 will work.
My lord, procedural.
First week of January. First week of. Yes. 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 Item 3.
May I please, Your Lordship heard this matter. I am the wife of Mr. Mir Raja Ali, against whom the prosecution has been launched. Till today, that investigation is going on. My humble submission before Your Lordship, on last occasion, Your Lordship also proposed that the account which has been freezed by the investigating agency, I am permitted to operate, and that may be released in my favor because I am suffering. I am a lady. And different bank accounts have been.
Ladies concerned, he is the wife.
Wife, mine.
And Your Lordship, their account has been released, keeping balance as on date of search in the day case. So there is no illegality in that order.
Yes.
That part. So but now he is seeking for release of fixed deposit, and she is claiming that taking plea that I have taken many money from different persons. I have deposited. Now they are demanding their loans. To
let us see what she is asking.
That fixed deposit page 17, Your Lordship.
17.
17.
Page 1 of mine. Page 2, paragraph 1. I have mentioned it.
Page 2.
That case is under section 13 to 13(1)(b).
Page 1 minute, and let me understand first. What are you seeking? Fixed deposit.
Fixed deposit.
Fixed deposit. How many fixed deposit you have?
Because I have.
First, there are 2 SB accounts.
My lord.
And 1, 2, 3 fixed deposits.
3 fixed deposits.
3.
That much.
3 fixed deposits. You want. Yes. What is the amount in the fixed deposit? Total amount?
Total amount, my lord. That is altogether, my lord. In fixed deposit, some amount to that extent, my lord.
You don't know.
One is 1,50,000. Another is 2,122 rupees. And just like my lord, another account is.
You let him furnish some security.
Bank guarantee.
Bank guarantee yourself.
I will produce my bond before the learning court below. Equally bond before the learning court below, and that is to be kept.
What bond?
That means, my lord, bond relating the person who is as a guarantor and to furnish the land property.
That's what I'm saying. Property security.
Property security.
Property security. Equivalent property security.
My lord,
right now. Petitioner is agreed by the order dated 13/9/2023, where passed by who has passed this order?
That is, my lord.
Special vigilance.
Malaysia, my lord.
Special judge Malaysia in
Criminal miss case number 112.
in criminal miss case number 112 of 2022, whereby his application, her application or his application?
My application.
Her application.
My.
Her application under section 457(2) CRPC has been rejected. The petitioner sought defreezing of SB account number. It a para 1 report. Para 1, but petition the para 1. SB account number so and so, and SB account number so and so. Apart from that, petitioner has also sought release of 3 fixed deposit being number so and so. Sign like notice was issued to the respondent. Mr. Mohan had already entered appearance, and on instruction submits that insofar as the savings bank accounts are concerned, those accounts have already been defreezed, maintaining the balance
as on date of search.
As on the date of as on the date of
search.
Search or seizing?
Search.
Date of search. And he further submits that insofar as the fixed deposit is concerned, the petitioner has to adequately furnish security for release of the fixed deposit. regarding head to the statement moved at the bar by both the counsel's opinion for the parties. I am for the considered view that all the three fixed deposit as mentioned above may be released, shall be released by the trial court on furnishing on petitioner furnishing property security of equivalent, property security of equivalent, and furnish an indemnity bond. Indemnity bond. With this observation, the petition is disposed of. Yes.
Obliged. Adjourn.
Yes, sir.
Five. Quashing of FIR matter and statute as well. The here case which is pending in the file of Lord Resident Kendrapada, here case number 1605, my lord. I have paid all the money and my client is suffering seriously.
Yes.
Annexure IV, the bank receipt mailer and annexure V medical copy, page 26 and page 27 to 30 mailer.
If the complainant is agreeing to this,
Ladies and gents,
I'll issue notice, bring the complaint. If complaint agrees, then I'll pass. If the complaint will not agree, then it has to be tested in the trial only.
well,
I'll just issue notice, issue notice.
I have paid all the money bank.
Petitioners are accused in FIR number so and so. Petitioners are.
A report of deposit of bank account, bank manager may kindly be called for my lord.
Petitioner, counsel for the petitioner submits that the
bank manager
the opposite party number 2.
Bank manager may kindly.
What are you talking? Why should I call bank manager?
I have deposited all the money.
Deposited. It is an interest dispute between you and the informant. I'll call bank manager.
My lord.
Don't make unreasonable prayer. This is 482 petitions. Am I a mediator here? I'll call everybody, ask whether he has paid or not, all these things. And have filed the bank receipt to that effect as annexure 4 to the present petition. Issue notice to opposite party. Yes, retainable. Yes.
Item 8. Your lordship, last in lordship.
Obliged, ma'am.
The rule plays to present petition lordship. But I have already looked later to the
Mr. Manti learned counsel, the state has not yet obtained the instruction. You have not got the instruction.
They want some further time.
One more charge giving. First week of January. First week of January. Okay. Second week of January.
First week or second week, man?
Second week. Yes.
May I please, your lordship? The petitioner filed this share for quashing of the order passed by the session judge as well as the order passed by the CJ Jagatsinghpur in 1CC number 102 of 2021.
Yes.
Lordship. Last week, lordship, director take instruction regarding whether the case is material or not. To that effect, there is two fold of a prayer minor.
What are you challenging now?
Challenging
You are challenging
in 1CC case number 10202 of 2021, order dated 4/5/2024.
What is that order?
The order of recall, the recall petition has been allowed. Kindly see me.
Yes.
Annex 3, my lord.
3 and 11.
Your lordship.
It was allowed. Then you file a revision against that.
Your lordship.
And the revision court has rejected.
Rejected on the ground of maintainability.
Yes.
But my prayer before this one, both the case, what is the order dated 4/5/2024, that has been allowed by the land court below, and both the session judge. Therefore, your lordship had maintainability regarding revision. That is revision, to that is revision and not permissible.
Now you forget about that revisional order.
Your lordship. I am
You just
challenging
ignore it.
your lordship.
And now you have challenged in 482.
Your lordship.
Concentrate here. Why are you insisting on, you have approached a wrong court
Your lordship.
in a wrong proceeding. You just ignore that.
Your lordship.
And you have challenged the main order also here. Come on and merit.
Your lordship.
Who are you? You are the accused.
Your lordship, I am the accused.
Yes. What is wrong in this order?
Your lordship, after completion of evidence, the recall petition is filed, and the recall petition is filed for a exit for some document. But prior to that, when the evidence,
Whose application was that?
Annexure,
Now, whose application was that?
the complaint application, my
Yes.
lord. Kindly say
He
annexure
want to
1.
examine himself once again.
Your lordship.
Yes.
Annexure 1, page 12.
Yes.
There is recall petition.
I'll issue notice, let us see. Issue
Hello.
notice to opposite party. 138 matter, we'll see. Yes, next.
And public. There is a IM, my lord.
No, 138 it can't be stayed. Yes,
Both,
next.
both in both
I'll sort it.
cases, issue notice.
I issue notice in both the application as well as.
Your lordship. Public.
My lord, the last occasion, my lord, record the order copy passed in Defamation case for the reunion between the petitioners and the victims. And I have also submitted the order copy before this one.
Received the copy of.
It's kitchen high. But
What are you asking here in this case?
in this case, the petitioner seeking for the entire quashing of criminal proceeding. As because the petitioner number 1 is the husband and the petitioner number 2 is the mother-in-law. And in the last occasion, in page number 60, annexure 3, 60 and 61,
Yes.
I am submitted before this one court that the matter is amicably settled between both the parties as informant and.
Then why don't you bring her? Opposite party. Bring her, I'll quash it.
My lord, since give bath a girl child and in the next occasion, I have submitted before this one.
Anybody is appearing for her?
No.
Somebody has to appear then. Either through counsel also she has to be represented. I can't quash it ex parte. She is the informant.
Well, it is a case under 1980.
Whatever,
matter
but,
is
at least she should-
Your lordship has
she
not
can't
issued,
appear, at least some lawyer should be appearing.
your lordship has not issued the notice, let the
I'll
notice.
issue notice, bring her.
My lord.
Issue notice to opposite party number 2, written evidence source. Okay. Yes.
May I please, Your Lordship? Your Lordship, there are two aspects to this case. We asked for quashing of the FIR. One is, my lord, how many times can a 161 statement be taken from a particular person, my lord? Initially, a statement was made by the deceased. She died in, this case is of 2011. FIR is lodged in 2011, my lord. The deceased makes a statement that the brother's son, that is one Pawan Sahu, came and administered poison to her. Anyway, she dies after 15 days. I'm not on that, my lords.
That is the dying declaration.
That is the oral dying declaration, my lords. Satish Sahu is the present petitioner before your lordship. Now, my lords, thereafter a husband's statement has been taken. This was in 2011, my lords. FIR lodged. Then 2013, the husband's statement is taken. My lords, he doesn't give any my lords reference to this particular person. He only says that this Pawan Sahu had come with another person. He doesn't state anyone's name. Then 2014, again he state 161 statement is taken. Again he reiterates the previous statement. Then in 2015, suddenly he names me. And my lords, the FIR is lodged in 2011.
Dying declaration doesn't disclose. Dying declaration, his name is not there. One witness, thrice 161 statement recorded. First 2 times, he has not taken the name. Third time he has taken. In 2011 FIR, if you keep on investigation for another 20 years, and keep on recording 161 and involve people.
And charge sheet has not been filed till date, my lords.
Why have you not filed charge sheet?
Let me take instruction.
if what happens in these kind of cases is 2011.
Yes.
IO might have been changed.
Yes.
The IO might have picked up the file and again statement is recorded. He gives somebody name, include him, like this.
Yes.
It will go on, then many people will come inside.
Yes.
So if you notice to opposite party, get instruction. What
Yes.
is it? Mr. Vishal accept notice. What is the status then? Nothing.
No charge sheet filed till date. We are in 24, 13 years have passed. Your lordship is directly covered by
Very, very
13th
bad.
case, my lord.
Very, very bad. I can't stay it also. You are on bail?
No. We are because we only want quashing of the entire proceeding. We have just said that no coercive action
Issue
again.
notice. No coercive action, what?
They may arrest us at any point of time. Because he has been named.
No, then where is your application? No coercive action
In the miss case.
It has a larger connotation, you know.
Maybe not to be arrested till the next date.
I'll put it on 23rd. You give me the exact this thing. 23rd. If notice 23rd. These are harsh cases. You please tell the IO and give it.
23rd of January?
This month.
December?
Yes.
Your lordship should put it in January. I won't be here.
No, I just want to know what is happening. Thereafter, I'll put it. Let him come. 23rd, let him come. Then, because if then I'll pass some interim order. Otherwise, let him get inside. Yes. 23rd.
Someone out.
12.
Oblige.
May I please? Your lordship, if your lordship remembers, last week I have made a submission that the petitioner number 1 is a Odia newspaper, your lordship, and petitioner 2 is the reporter. On the basis of an FIR, report has been made, your lordship, where the opposite part number 4 says that it is defamatory to him. Subsequently, the lady
because the
on the basis of FIR
reported the FIR.
Yes, on the basis of FIR I reported it. Subsequently,
have I issued notice?
No, your lordship, because the impugned order is somewhat while filing, your lordship, it was not there, your lordship. The additional affidavit.
I issue notice.
Yes, your lordship.
I issue notice. He is the reporter.
Yes.
Some FIR was registered.
Yes.
And he reported that FIR is registered. What can he do?
Yeah.
What defamation about it? The true facts.
Yes.
If FIR would not have been there, I can understand.
Yeah.
FIR is already there.
And so
He reported that there is an FIR.
Subsequently, when the lady changed her version, that also has been reported.
Then, simply issue notice. Returning on so. In the meantime, proceeding in so state. Which proceeding give the report?
Yeah, great.
13.
Wait, please, your lordship. Item number 13, my lord. Here, my lord, the police handed with our Gosala 19 number of cattle without considering our submission.
Issue notice.
Notice and stay is required.
Why stay?
Because, my lord, the learned court below directed to release the cattle without considering the ratio decided by this court. And, my lord,
you have a Gosala.
Gosala, my lord.
But the problem is the Gosala people are taking care of the cattle.
Yes,
which is part of what you call the
compulsion work.
Slaughtering and all. And then stay of operation of the engine order.
Grateful, man. Notice OP2 notice.
Notice to?
OP2.
OP2.
The claimant.
This Pratap accept notice. Yes. And staying is not prejudicial. The cattle are taken care of by them. If you don't stay, then the cattle are nowhere, neither here nor there.
The cattle will suffer.
So yes, stay.
Grateful.
Okay.
15.
My lord, item 14, my lord, I am the petitioner in this case.
15.
No,
14. I don't know. Your friend has done it. No. Okay. So 14. Mr. Das is not well.
This is suffering.
Somebody mentioned.
Sangram Das. My lord, what happened in this case? That time is similar case, lordship passed this order to direction.
He is not there. So what to do? I'll put it in the first week of January.
I got date fixed.
Date fixed. Date fixed. He's not well.
Monday. Similar case, order pass. Order pass.
First week.
My lord,
Not possible. Just see these 3-4 days is very yeah.
And asanta
And
saptah
what is the urgency? It can be done.
Monday, Tuesday, these दिन working day any day till also Monday, Tuesday. Try more level.
Not possible. 24th लगा दो देखते हैं.
आगे देखिए more level test करें.
Yes.
का similar order pass अपन दे चंदी order more case रह जाए.
What is the urgency? It will be done by if it is not this court, the other court also. Because I have already allowed.
अपन एक order दे चंदी पर अन्य मानो.
So that you show that order to the.
आगे हम कितना दे ଦେଇଥିଲି ସେଇ order ଟା ମତେ last occasion ମୁଁ ଦେଇଥିଲି order.
Okay, 24th. Why to waste?
ଆଜ୍ଞା.
24th. Okay. Yes. 15.
15, my lords, this, he has, it's a Belgium matter basically, my lords. He could not attend the, he was unaware.
When was the bail?
My lords, bail was granted at running page 48.
Vigilance.
17/1/17. And he was released on bail. And thereafter, my lords, on 3/1/22, the case was also split up and the NBW was issued against the petition.
3/1/22,
that is at running page 51.
You give the bail date. When you
Bail was granted on at 17/1/17.
17/1/17 and 3/1/2022. Oh, NBW. Sorry for that. But your pay cost. Vigilance Baripada
Bill pay cost.
1,000.
Deeply obliged. Well, I have just one problem. I have to appear before that honorable court. I'm in custody. He's in custody in an ED case. So after he gets bail, he will appear.
No, I did follow. He's custody in some other case.
Yes, he is custody in some other case. He can do it.
Let it be, no problem.
Appear through the chamber. Yes, obliged.
One minute. He is there. I pass the usual order. He is there in custody in some other matter.
He is involved more than 300 rupees fraud.
I am not doing anything. He will appear and seek remedy available.
Yes, those with all the establishment have left the condition. So that is the reason why condition you lost me.
What condition you want?
That
That the trial court will in the bail. I am not giving bail. Nothing. I am not doing anything. I am only saying that he will appear, resort to the remedy available to him under law. What else you need? Yes.
Obliged.
And when he applies for bail, you tell all these things to the court. Yes.
All co-workers have been released on bail. This under
Custody since?
Custody since.
Yes, Jana, you have?
Yes.
Instruction and all. Yes.
Petitioner is in custody, my lord.
You start reading the file now.
No, man.
Read it and come. I'll put it the first week.
No, my lord.
Then you.
2 to 3 items back.
Huh?
Pass over, my lord.
You say that. Pass over. Okay.
Yes, my lord.
17.
May I please, your lordship?
Yes, sir.
395 read with section 25 and 27 of
Custody. Custody since?
custody of 28th of March 2024. Co-accused has already granted bail. Same thing.
What is this?
Yes, similar.
How many cases?
16 criminal and
16 cases.
My lord.
in similar nature, man. And for that reason, your lordship is directed to file the comprehensive affidavit.
You file the affidavit.
My lord.
File the affidavit. Not here. You have to file. Now it is.
My lord.
File. The counsel for the petition seeks wanted to file the affidavit regarding the antecedent of the petitioner. Let him do so. Read the matter. Yes. File it immediately. Yes.
18.
Sorted matter.
Yes. You should have filed by now. In the court, you can't give these things. Yes.
My pleasures.
Yes, sir.
As the petition is custody on 24/9/2022.
24/9.
Yes, lordship. 2022, lordship. And the offense is 302, lordship. And in this case, lordship, 8 witnesses have already been examined, lordship.
And so far the 5 witnesses, official witness and 3 is independent witnesses. That is that is no direct evidence, no eyewitness, nothing is there. That is only cases of circumstantial evidence received. And police only based on the 3 witnesses, Tilochan Bainpati, Govind Raut and Ashok Raut. And both of us examined, I have annexed the document, the evidence of deposition copy of Govind Raut and Ashok Raut. They have declined before the trial court. So that is the postmortem report is received. That is the hard and brought to use to open the hard injury of the hard and blunt to open. But the police has not.
Yes.
My lord, 2 persons your lordship has granted bail. Rahul Ponda
Rahul?
and Rahul Ponda.
It's a number. C026 for that. Right now. Oh, gee, Shankar Naik.
Sorry, here the complainant, my lord, Trilochan Bahinipati.
Trilochan Bahinipati.
He is the, my lord, he is the vital witness, my lord. He has seen last with this petitioner along with the deceased man.
Trilochan Bahinipati, yeah?
After examination of that Bahinipati, your lordship.
Lordship, 3 witnesses, Lordship, Tilochan Bainpati, Govind Raut and Ashok Raut. Both of 3 was present. They have pulled her wife. That is the wife, and the petitioner is the husband, Lordship. And they have residing since last 1 year in the abandoned building in the Pudi, Lordship. And continuously they are staying in a abandoned building in the particular spot, Lordship. And 3 witnesses at the time of the incident, 3 witnesses were present: Govind Raut, Ashok Raut, and Tilochan Bainpati. And Govind Raut and Ashok Raut already been examined. Tilochan also examined, but I have not obtained the copy, Lordship.
Get the copy, Trilochan. If it is examined, that's what is objective.
Because the Lordship.
Get the copy of Trilochan, I'll consider it. Consider after Trilochan. Trilochan is already examined. Get the copy of the evidence. Yes.
Certified copy.
I don't need certified copy. You just give that copy. I'll just consider.
23rd.
23rd, 24th, 24th. Yes. Next.
Pardon, Lordship, 24th.
Yes. Next.
19.
Alright.
Yes. Yes.
19, my lords, last occasion, lordship directed to comprehensive affidavit regarding the present petition, my lords.
Yes. Notice have you got it?
My lords, I have also filed, my lords.
My lord, yes, filed.
Copy same day, my lords. I have also filed, my lords.
Filed put immediately. Just password.
Password. Yes. Next.
21.
20 May. My lord, the petitioner is in custody since 3/8/2023, my lords.
3/8/23.
My lords. The allegation is that, my lords.
3/8/23.
The allegation is that, my lords, the petitioner and the deceased both went to consume liquor, my lords, and one of them returned home and other one fell from the bridge and died, my lords. The medical report is here, my lords. It has been,
yes.
The above mentioned neck injury can be possible by fall from height, my lords. And all the depositions have been submitted. Till now, 7 witnesses have been examined and submitted. On last occasion, my lord had told it to collect the deposition of the mother, my lords. I have submitted the deposition of mother.
Where did you read that? Which part of the
First line, my lords, the opinion. The above mentioned neck injury can be possible by fall from height.
External injuries
Yes,
are
my lords.
antimatum in nature. The cause in blunt force and come in contact with the rough material. The above mentioned neck injury can be possible by fall from the height.
My lords, my lord, there is no eyewitness in this case. And my lords, everyone is saying that we saw them buying cigarettes and disposable glass, my lords. And on last occasion, my lord had told to collect the
case is based on the circumstantial evidence and the last chain theory, lordship.
And out of 31 witnesses, now date 7 witnesses are already been examined. And learned trial court and impugned order rejected that there is some other material witnesses are to be examined, your lordship. My respect, your lordship. There is another 3 material witnesses not yet been examined, your lordship. Let me first examine.
My lord, the informant.
What are the evidence?
Evidence, your lordship.
Both of them were together.
Yes, your lordship, but
and both of them drunk.
Yes.
And he says that he fell down from the.
No, your lordship. That is not. They both went to the jungle and take wine in the that. And accordingly, the present prisoner returned to his house. And while the present mother of the present deceased asked where about my son.
No, my lord.
The fact is that in the night 4 a.m. he has reported that your son's
whether he has returned or not, he asked, my lord.
In the
What is the motive?
Motive is not, but last scene theory is there and certain evidences clearly.
Motive has to be there.
Motive is not that.
My lord, the mother, the informant.
Friends and the present prisoner.
Let us see the evidence of these witnesses.
Yes, they are supported, your lordship. PW 6 and 7 is the mother and wife of the present deceased, your lordship.
Let us.
The wife was not at the spot. The next day she came from Bhubaneswar, my lord.
Yes, but PW 7 will kindly realize the mother of the present deceased prisoner, lordship.
Yes.
But present deceased of the deceased mother, your lordship. A Santa Radio, lordship.
She is also saying that they both of them
It's
to consume.
clearly supported the case of the person, lordship.
They are hearsay evidences. Yes.
May I read, your lordship, the evidence of the PW 7 mother of the deceased?
7, huh?
Yes, your lordship. A Santa Radio, lordship.
Yes.
On 25/2023 at about 3:09 a.m., A.S. Diban Reddy called my son with him to consume liquor, but my son didn't return in the said night. In the midnight, about 3 a.m., A.S. Diban Reddy came to my house and asked about my son, to which I replied that my son had gone with you at 9 p.m. and why you are asking me about him.
He himself asked me.
Let me finish. I'm submitting. In the morning, the next day, the dead body of my son was lying under the culvert, near the end of our village. I went to the spot and found the dead body of my son. There was injury noticed on the body of my deceased son is Babla Reddy. My son deceased is Babla Reddy. Police came to the spot and they asked me to put my LT in a paper. So I, knowing nothing, put my LT in a paper. On that day, my daughter-in-law, the wife is staying at Bhubaneswar, lordship, for a labor work, was at Bhubaneswar, and she came to our village and asked me and my other daughter-in-law, and thereafter lodged FIR, lordship.
What is the motive now? Motive is not.
But
more than 1 year in custody, my lord. So
and the last scene theory, jo dukan se kini ki nele disposable.
All these things are allowed unless
not examined. State examined hai nahi. Last scene yes, lordship.
Pushpa Chaudhary.
Yes.
Pushpa Chaudhary, G. Rabindra Reddy.
Yes.
They are vital witness. Case has been posted to 23rd.
Put it the second week of January.
The vital witness. Pushpa Chaudhary and my lord G. Rabindra Reddy.
The counsel appealing for the informant and the state submit that 2 vital witnesses, namely Jeevan Reddy and
Pushpa Chaudhary and G. Rabindra Reddy.
Chaudhary and Jeevan Reddy have not yet been examined, although 8 witnesses have already been examined. Therefore, and the matter is fixed for
23rd for their evidence. 23rd December.
23rd of December. This is the matter in the first week of January, and the trial court is directed to ensure that the said above 2 witnesses are examined preferentially over all other witnesses. Please. Yes. Next.
22, a lot of this matter relating to the Sambalpur cup syrup matter also last in also directed to file the particulars on the date of when the prisoner arrested and the antecedent part also. I have clearly filed.
How many matters?
There is
that is that matter.
22,
24,
24, and 30. Yes.
That is that matter. Your lordship says last occasion directed that he was
Yes.
5,000.
Your lordship last time has taken a view that those are arrested from spot, they will remain.
Yes, that's what I want.
Only 2.
So সেটা আমি লিখি দিয়েছি on the spot জଣେ arrest
On the spot କିଏ ଥିଲେ ଦିଅ ନାହାନ୍ତି?
ଖାଲି 2 ଜଣ ଆଜ୍ଞା ହେଇଛନ୍ତି, ଗୋଟେ ହଉଛି ରୋହିତ ଅଗ୍ରୱାଲ ଆଉ ଗୋଟେ ପିଙ୍କି ମେହେର।
ତାଙ୍କୁ ଦିନ
ଆଉ ସବୁ
ଛାଡ଼ିକି ବାକି ସବୁ ଛାଡ଼ି
confessional statement of the
No, Rohit,
But there-
no separate seizure was made, na? No
may not be,
separate
but
seizure was made.
may not be, but he was there in the when the search and seizure was made.
what is this side?
ଖାଲି आपको କହିଥିଲେ କେବେ arrest ହେଇଥିଲା ଦେବ।
नहीं नहीं किए अरेस्ट स्पॉट
the arrest on the spot ଲେଖା ହେଇଛି।
पिंकी
and Rohit।
पिंकी and Rohit
ଆଉ ପିଙ୍କି ର ଗୋଟେ co-accused ଅଛି, he was not there, but subsequently he was
and on the basis of Pinky Mayor's
Mayor
statement
confessional, all has been added and as accused, there is a racket minor.
right. item number
Item 22 lordship BLPL number 10435
1 minute 22
BLPL 1
item number
22 with Ogral is BLPL 1046 item number 22 sub item
and rest number बताओ ना।
next होउछ मान 10487
रोहित अग्रवाल हाँ?
आगे
10,487 राजेश नाग. Not there.
Rohit
confused for them se to sab
item number you tell me I'll let me
item number sub item
I understand item 22 and item 30
sub item 2
30 2 ଜଣ ଅଛନ୍ତି 30 super
I it's better that I should read it. The way you people are assisting, it's better that I should read. Item 30 and what else?
30
22, 30 and
22 30
I'll pass the order.
item ballot by item 32% 2% are the petitioners. So for one is concerned ballot that Pinky Mehra
Pinky Meher
going to be disposed of as ballot.
And the other, I'll give all the matters at a time. I pass the order. All the bail application in one order. I'll pass. Yes.
I may permitted to say, my lord, one sentence, my lord. Sub item 10460 Rohit Ograwala. He was arrested on the spot. No separate seizure list was made, my lord. But
You repeat, you will repeat it.
My lord. Two criminal.
Why are you creating problem for others?
No, not. I will take care of my client.
governments and my lord senior.
Yeah, anyway, she has the right to speak.
Only two antecedent, but not similar type. Not similar type.
Wait for some time because spot arrest.
Yes, my lord.
Use recovery and all.
Similar antecedent. Two antecedent.
And all the accused you have given the date of custody?
For better appreciation lordship, I will file the details of the today's items. Those are listed for today. I have given the written notes argument better.
What written bail matter? If I am starting written argument, then
and involvement whether
then I can't. I don't think I can do anything.
Yes, sir.
One bail application is enough.
Yes, lordship.
I take only seconds to decide. You because all of you are not assisting properly. Therefore, I would have dictated by now. I'll do it. I'll take 5 minutes to do it.
One by one take away later.
If everybody shouts, then it's not assistant. It's chaos.
Best
Anyway, we'll do it.
23.
May please lordship.
Yes, sir.
In the last occasion, the lordship has directed the state council to go through the page number 38. Kindly have a glance. Page
38 of your petition.
My lord. Paragraph 6.
Yes.
My lord got it?
38, huh?
My lord. Running page 38.
Yes.
May I read, my lord? Paragraph 6. My lord.
Yes, I'm there.
Considering the materials on record and further on a plain reading of the FIR, this court is of the considered view that prima facie a case is made out against the present petitioner. However, it is open to the petitioner to challenge the same at the time of framing of the charge. Further, considering the submissions made by the learned counsels appearing for the parties, the petitioner is directed to surrender before the court in session over the matter within 4 weeks from today and move an application for bail. In such eventuality, the court in session over the matter shall do well to consider and dispose of the bail application of the petition on the same day. While considering the bail application of the petition, the court in session over the matter shall keep in mind the fact that nothing has been recovered from the exclusive and conscious position of the present petitioner, and as such, the bar under section 37 of the NDPS Act would not be attracted to the facts of the present case.
Yes.
What has happened? 5 persons were having
Custody since?
Yeah.
Custody since?
Custody since, my lord, 9/8/2024. FIR 10/3/2023. After 1.5 years, he has been arrested. Charge sheet date is 1/8/2023.
1/8?
2023. 1/8/2023. 5 ଜଣ ଲୋକ ଆଜ୍ଞା ଜଣେ ଏଇ ଯୋଉ ପିଟିସନର CRLMC ର ଅଛି ସିଏ ଆଜ୍ଞା 2.5 କ୍ୱିଣ୍ଟାଲ କଣ୍ଟ୍ରାବାଣ୍ଡ ଗାଡା 7 bags ରଖିଥିଲା ପୋଲିସ ଗେଭ୍ ଦେୟାର ତାକୁ ଧରିବାକୁ ଚେଷ୍ଟା କଲା ହିଜ ହେଞ୍ଚମେନ୍ ଯୋଉ ଗାଁ ଭିତରେ ଯୋଉ ଲୋକ ଥିଲେ ସେମାନେ ସବୁ ଘେରି ଗଲେ ତା ଭିତରୁ ଏଇ ଯୋଉ ପିଟିସନର ଯାହାର CRLMC ନମ୍ବର ଫାଇଲ ହେଇଛି ଯୋଉଥିରେ ଭ୍ୟୁ ଦେଇଛନ୍ତି ଅନରେବଲ ଜଷ୍ଟିସ ଆଦିତ୍ୟ 37 will not be bar ସିଏ ତାଙ୍କର ଆଉ କିଛି ଅଲଗା ଲୋକଙ୍କ ସହିତ ମିଶିକି ସେ 7ଟା ବ୍ୟାଗ୍ କୁ ନେଇ ପଳେଇଲା ସୋ କୌଣସି ପୋଜିସନ ହେଇପାରିଲାନି ସିଜର ହେଇପାରିଲାନି ଆଉ ନା ସିଜର ଲିଷ୍ଟ ବନା ହେଲା ସେଇଥିରେ CRLMC ଅନରେବଲ ଜଷ୍ଟିସ ଆଦିତ୍ୟ କହିଲେ 37 will not be bar.
The manner and involvement present accused petitioner lordship the present police are raiding in a house at that time one another accused is lordship in that house lordship and there is the contraband ganja 7 packets of ganja 205 kg ganja is there at that time
250 kilo
50 kilos ganja is there in it. While the present police is in that house the present petitioner and others atrocity towards the police and not allow to deter the public servant
prevented.
Yes, your lordship. And present person and in absconded. Though is not exclusive position in that house, but the manner and involvement of the present accused person is very your lordship and absconded from the spot, your lordship.
Madam, the prime accused person is Brahmaraj Bureau, which is
one after another.
And injured the one constable and homeguard also injured by the present person others.
Injury report.
ଖାଲି କହୁଛି କଣ ମୁଁ ବେଶୀ ଡକ୍ୟୁମେଣ୍ଟ ଅଛି ଅଛି କାରଣ ମୁଁ ଆପଣଙ୍କୁ କଣ ଇଏ କହୁଛି ଆଜ୍ଞା the two public servants also injured by the present petitioner and others ଅଛି
What is the charges charge sheet filed against?
My charge sheet is 341, 294, 323, 353, 354, 506 along with 20B and 2C.
20.
All the offences are magistrate tribal offences, my lord, except 20B 2C. And my lord, the person who
Then
which is
186, 332 and all are there.
my lord, the present petitioner was the henchman. The main petitioner who was having the contraband ganja control over the master is Beniamohan Biro. Before this CRL जो order टा अपन हजू देखिले 38 टा ସେଇଥିରେ ସେ view ନେଇଛନ୍ତି. He is the principal accused.
Have they got bail any accused?
This person has got bail.
Who? Benia? No, this is not bail application.
No, co-accused के जाए ना.
That's what
co-accused के जाए ना. The Beniamohan Biro he has given that 37 is a bar, is not a bar. So absolute my lord, जो seizure किसी है ही नहीं तो possession में बाहर ही बनी. That too, this petitioner was not present over there, my lord. Being a heinous offence of 20B2C, the 37 will be a bar whether he has been in possession or not.
କାତି ଖଣ୍ଡା ଧରିକି ଇଏ ଗଲେ ଗଞ୍ଜାକୁ ନେଇ ଗଲେ
ଇଏ ନଥିଲା this petition was not there, my lord.
Yes.
Other henchmen has taken that.
Okay, let us see what is his name. Name is
Krishnaraj Biro.
Krishnaraj Biro. Let us come to the charge sheet.
My lord.
What are the allegations? Let's show you. To me, Krishnaraj.
Page
34. Yes.
Page 12 lordship is in the page 12 by last
Charge sheet, sir, charge sheet 12 line. Charge sheet is from 31.
Come to page 31.
My lord.
relevant page 32 lordship. By that time, suddenly the family members of the supporters of the accused Beniamohan Biro,
my lord,
that is page 32 lordship. In the mid lordship, in the first paragraph lordship, Bero, namely Krishnaraj Bero, son of so and so, Suleman Bero, son of so and so, Prasanna Bero, son of so and so, Sasan Pani, son and so, all our village Buri Padara and so and so came to the spot house, herod us and abused in absence language, assaulted our staff and threatened us to kill in life by sewing sword, kati, tangia and forcible taken away, detaining Beniamohan Berio with them along with the said 7 numbers of ganja jerry bags.
That's what I am saying, my lord, whether ganja jerry bags have not been seized.
But the conduct also is not that
they are
second week of January.
Second
week of January. Yes. Next.
24.
Please, your lordship. Lordship, I am through VC from Sambalpur, lordship.
Yes.
Lordship, here the offences are 457, 380, 411, lordship. And here in this case, lordship, the accused petitioner forwarded before the London court on 4/5/2024, lordship. Charge sheet is submitted before the London court on lordship 3/7/2024.
Your Lordship, he has two antecedent. Your Lordship, previous occasion, Your Lordship directed to file an affidavit with.
Has he filed affidavit?
Yes, I have filed it, Lordship.
The copy of the
The copy already received, Lordship. On the last occasion, the Learned Standing Council also submits that the copy was received. On the
You
last
have the-
occasion.
No, here my record. does not
Verified,
show-
verified.
Yes.
24. Verified. Then counsel for the petitioner submits that he has already filed the affidavit, but the copy of the affidavit stated to have been not served on the state council, hence release the matter on 25. Yes.
25.
कितने बिल मैटर लगा रहे हैं? 5 bill matters.
20B2C, my lord, nothing has been seized from the conscious possession.
Recovery? Recovery how much?
Recovery of 500 some kilogram from two accused persons, 520 kilograms. And on the basis of their confessional statement, they stated that 3 persons.
Your
were there.
custody since?
I am inside the custody 11/11/2023 and the FIR is 10/6/2023, charge sheet on 5/12/2023.
510.
5/12/2023 charge sheet. I am
Yes.
inside the custody.
What is there?
Who?
Against him?
Last occasion, your lordship call for this and observed that if he
The CD has not yet.
for more than 1 year.
Not received.
Not received.
Twice.
500 kilos.
Yes, sir.
But no conscious possession.
Let
lordship
counsel for
observed
the,
that-
therefore, the Mr. Bashal and counsel for the state submits that he has not received the case diary in the present case and seeks one final opportunity to obtain the case diary means the matter in the first week of January. Yes.
May I please, Your Lordship? Offense under section 417 and 420 of the Indian Penal Code. Since 9/6/2024, in between charge sheet already submitted 36/2024. Allegation in the affair.
Custody since
39/6/2024.
9/6/24. Okay.
Charge sheet submitted 36/2024.
Yes. Yes.
Allegation in the affair, my lord, present petitioner involved in misappropriation of the 504 quintal of the paddy.
500?
4
Nine.
quintal.
509 quintal.
504, 951 already stock thila. Good down.
You argue the matter, you address this court, you need not address him.
504 quintal of the paddy, rupees 11 lakh, my lord.
Paddy?
Paddy, my lord.
Yes.
As a secretary, collected stock and secretary to rises. Number of open suicide was for
Why are you reading what? Tell me you will read from the beginning to last or what? Tell me what are the allegations against you?
Allegation, my lord, 504 quintal of badly misappropriation the petitioner.
What are you are what? You are working where?
As a society secretary.
Yes, Mr. Vishal.
Yes, he did.
The 420, how many days you will keep him?
Yes.
So tell me what are the allegations? I will grant him bail.
Allegation is that he has misappropriated the 504 quintal of the paddy, which amounts to 11 lakh of the money.
What was he?
He is the secretary of the cooperative society. In the secretary, he has misappropriated.
It's all right. Charge sheet has been filed. What will you do? Convict him. Right. Okay. Petition is accused and so on, so on. Okay. Allegation is the petition. After investigation, charge sheet has been filed in the present case on 30th of June 2020. June. 36/2020. The petitioner is in custody since 9/6/2024. Regarding what to the fact that the petition charge sheet has already been filed in the present case and petitioner is in custody since 9/6/2024. You have any criminal antecedent? Petitioner is a first time offender. He is working as the secretary of the cooperative society. Secretary of cooperative society. I mean, trying to enlarge the petition on bail and grant bail. Yes.
27.
27.
May I please? Your
Yes.
Lordship? Your Lordship granted bail. Your Lordship come to page 14, page, that is, I have annexed my bail order of your lordship page 14 towards last.
Yes.
It shall not release subject to the verification of similar type of accident.
Yes. How many?
And in state of Odisha, there is no accident. It has been released.
I told you to file an affidavit.
I have already filed the affidavit.
Where is that affidavit?
That is flag F.
Copy that they
हाँ दे दीजिए कॉपी दे दीजिए ऑलरेडी काली दिया इसे आगोट नंबर पे हमारा सिकाच neither he has been apprehended nor anything else nor notice in state of West Bengal, neither in the court case number.
And you say that you know, have no knowledge. What is the recovery there in that NCB case?
I do not know. Till today, I do not know. Till today, my lord. Neither he has been a.
Yes.
Yes, we have sought for instruction from the concerned.
In the affidavit, you seek instruction because it is the NCB case.
Copy of the affidavit.
I have already solved.
NCB cases are huge cases.
In Calcutta.
Huge cases.
Yes.
You may be involved in some international racket and nobody knows it. NCB is investigated.
My lord, I am conducting one case in Khorda. DRI, Director of Revenue Intelligence. She is the contraband article weighing about 50 kg. Because
maybe,
of,
let us see what and see. So, Mr. Das had filed an affidavit of the petitioner dated 17/12/2024. Mr. Vishwal seek 1 week time to obtain instruction regarding the FIR. Sorry, said affidavit. Brings the matter in the first week of January. Yes.
28. 28 May. This is the second bail application of the petitioner. First bail application was during investigation, and in the present petitioners, 3 petitioners are there, ladies.
Charge sheet filed.
Charge sheet filed, and thereafter 2 witnesses were examined, and including the informant.
No, it's 376.
Not 376. Charge sheet has been filed under section 450, 302, 34 of IPC, 34 and 452 of IPC.
Yes.
No 376 is there. These petitioners are ladies, and here the prosecution case is that one Kundeswara Majhi was tried to rape the deceased and by that time the present petitioners, this is the informant affair story, present petitioner entered and assaulted the Kundeswara Majhi and both of them, and thereafter the deceased died after 5 days, and thereafter charge sheet has been filed against these 4 persons under Civil 302, but in the meantime, informant was examined.
376 is taken out.
No. 376 was against Kundeswara Majhi. He is not a petitioner here, He is the accused, but in this case,
show me the charge sheet. Show me the charge sheet.
Yes. And I have held the deposition copy.
This is the case of an extramarital affair. The deceased lady was in affair with this person named Kundeswara Majhi. The villagers used to protest regarding.
I want to know whether 376 then notice has to be issued. That's what I'm wondering.
Charge sheet.
In the charge sheet, whether 376 is there?
No, charge sheet. Charge sheet is not. That Kundeswara Majhi, he is not accused in the charge sheet,
Yes.
Here what happened, the informant, I have filed the deposition copy, your lordship, the informant is the prime witness, There is no eyewitness, and I have, that is at flag K.
Flag A.
Flag K in the next bail application. There are 2 bail applications. I have also supplied copies,
Yes.
And 2 witnesses were examined recently, including the informant is PW1. He stated that.
Flag K. What is
Flag K. That is PW1 Birendra Patamaji. Your lordship got it?
In second, there is no flag K.
In the second bail application.
Yes, second only.
Sorry, flag Z, flag Z.
Yes, I got it.
Flag Z.
Read it.
Birendra Patamaji, PW1. Along with a memo, I have filed 2 depositions.
About 8 months back, I was in my house and I go village location Maji called me. What is your name?
Our name is Sudari Maji. And there are 3 petitioners. They are ladies.
And told me that
Dakkali Maji and Padmini Maji.
That's right. And after getting this information, I immediately went to the meeting. So the line of the work. I've heard from the notice. He is not supported.
Not supported.
Yes.
He stated that Kundeswara Maji has killed the deceased Miller, but that Kundeswara Maji is not Miller. Here is a petitioner's Miller.
Charge sheet has also not been filed.
Charge sheet has not been filed.
File against Kundeswar.
Yes, Miller.
Yes.
Yes, Lordship, actually the thing is that.
And we are in custody, Lordship.
All of you are ladies.
All of in the first bail application, all we are ladies, and the second bail application, Mittu Maji, he is a gents. He is also co-villager and similar
He is
situation.
the prime accused person in this case, Your Lordship.
Okay.
Me too. Okay.
Me too much.
Then they
Lordship, kindly hear me. This is all due to the extramarital affair between the deceased person and this one Kundeswar Maji. The villagers and co-villagers used to protest regarding their relation. And subsequently, one day, the villagers caught hold of both of them, and they entered into the house of and they were in the compromised position. They started beating and assaulting.
Beating whom? Both of them. Kundeswar and all.
Both of them.
Yes.
Yes. After this Kundeswar Maji, somehow or other, he escaped from the scene. However, this lady sustained a severe beating injury on her neck, chest, and other
And died.
areas, and she remained there. She was bedridden for 5 days. She was not shifted to hospital. None of the other relatives and other people.
Who are these ladies? Who are these ladies?
Yes, Your Lordship.
What are the allegations against these ladies?
Padmini Maji, Dokkari Maji, Sudari Maji, and Mittu Maji. These are the 4 main accused persons. But in the 161 statement, the main eyewitness in this case is Kundeswar Maji. He has specifically stated all those things. Also in the 164 statement, he has exactly corroborated the same thing.
Let Kunduli Maji.
Kundeswar Maji ଆଜିରେ ତାକୁ accuse କରିଛନ୍ତି informant. Kundeswar Maji ତାକୁ ମାରି ଦେଇଛି ବୋଲି କହିଛନ୍ତି.
No, but Kundeswar Maji has seen that both Kundeswar and that deceased were beaten up by these people.
Yes, sir.
Because they were having extramarital relationship.
Yes,
You read it 164.
164. Yes. The same thing 161 and 164 he has followed. So a little bit hazy or
Yes. Give an overall idea.
Yes, sir.
Yes.
May I pray, Miller? In the meantime, whether he may I pray, Miller? In the meantime, whether he was examined or not, I will take instruction.
29/7/2024 for alleged submission of offence under section 302/450/34/452 IPC. In the after investigation, it revealed that the present petitioners were against the relationship between the deceased Durvati Maji and Kundeswar Maji. They got hold of both of them while they were in a room and beaten black and blue. As a result of which, although Kundeswar Maji escaped from the spot, but Durvati Maji was seriously beaten up. She was not even taken to hospital and remained in the room for 5 days, and eventually succumbed to death. The next one. During investigation, 164 statement of the injured Kundeswar Maji had been taken. He has very specifically attributed specifically made allegation against the present petitioners. Therefore, I am not inclined to enlarge the petitioners on bail. However, liberty is granted to the petitioner to renew their bail fee after the white witnesses, particularly when after the examination of Kundeswar Maji. And the court is directed to see that the vital witnesses, particularly Police Marji is statement is recorded preferentially over all other witnesses. Yes. Yes, next.
And the next bail application also.
Yes, same. Yes.
That the position copy I have filed, also informant has not supported.
Injured witness is there. Yes. Next. Same. Yes. Next.
31.
Yes, sir.
I think against one of the legal heirs.
I'll just check it up. Service. Service on the opposite party. Answered. So it's address he left without instruction.
So actually 1B law says if it is sent in the correct address, even if the person has left, it has to be held to be sufficient.
That's
Right. Then 1C tracking report has to be seen.
1C देखो.
These are all correct address.
You take the notice.
Sir?
Take the notice if you can. Take the
Tracking report has not come. Not served. 1C, 1D, 1C. See, the person is dead. What is the report?
Black Z.
Black Z, eh? Z है
नहीं? Date किया
Z. Consignment. Item bag. What is bagged? BAGGED bagged. What is that?
Bag.
Still awaited impact.
2811.
I'll take it up in the first week. Let us awaiting service on the opposite parties. DC matter answer. Yes.
32.
32 and 33, my lord. The file is because initially the higher education was a separate wings, but now there is an
So what do you want? I put it
some time.
Monday for 30 to 30. Monday बोल रहा हूँ. Immediately second week.
31 and 30.
31 30.
32 and 33.
32 and 30. Sorry, 32 and 30.
34.
Yes, madam.
Notice or if sufficient.
Give sufficient notice. Awaiting service for sufficient. The service on the opposite party is all the opposite party. All the opposite parties.
Yes.
Sufficient. Sufficient, but none appeared for them. None had entered appearance in the interest of justice. Second week of the second week. Let us see. Okay.
Item 16, previously Lordship, I have handed over the copy of the orders with respect to the co-accused persons who have been granted bail. In order number, order passed in 4889 of 2024, after verification of the record, it reveals that 3 persons are the principal accused, not the present petitioner. A petitioner, while he was in custody in connection with another NDPS case, he was taken on remand on the allegation of conspiracy to commit the offense.
Yes.
That the paragraph 7 of that order, Your Lordship, I have already previously handed over. that 4889 of 2024.
You are in custody in some other case.
Yes, Your
You're
Lord.
taken into
Taken remand in this case on 12/9/2023.
12/9?
12/9/2023. And
22.
yes, and similar situated with other co-accused persons who were also on the basis of the confessional statement of the accused Prashant Sahu, Ramo Raula, Kalia Sahu, and Rahul Ponda. They have been, Your Lordship,
Granted bail.
Granted bail.
Yes. What is the difference?
Your my lord, this petitioner.
Yes.
So wife expired, my lord. He suspects that he deceased as witchcraft, for which this petitioner, along with 3 your lordships, has already given a finding that they have been accused on the basis of the State Council, my lord. View, my lord. Then there is they planned in the jail, and after they came, these 3 persons came outside the jail, my lord. They have killed them. This is the case, and your lordship has granted bail out of.
See, Rahul, I have granted bail to Rahul.
My lord.
Rahul and
Ramo
and Kalia.
Kalia.
And your
And
lordship
what is the difference? Sorry?
This petitioner's wife was for which my lord he suspects, Pradeep suspects, this petitioner suspects that due to the witchcraft of that deceased my lord, his wife expired, my lord. And this petitioner, along with that 3 persons which your lordship has already named in the bail application, which your lordship has allowed, they have chalked out a plan. Then that 3
The
persons
petitioner is also one of the conspirators to kill his wife.
No, not killing his wife.
Wife की मारी ना
This conspiracy part is concerned.
wife टा मरियला जो मरियला सी जो deceased तक witchcraft करके मारची बोली तारों टा killing सर
His wife died.
Yes.
And the deceased, he is suspecting that
deceased is witchcraft.
Deceased is the father.
And he has taken help of that Rahul and all.
3 persons, and that 3 persons while on bail, they were also in custody.
You are in custody since?
I am in custody since 12/9.
What is the stage of the trial? There is no other.
Some witnesses have been examined.
But what about the witnesses? Whether they have supported the case?
But the witness, there is no eyewitness to the offense.
Deposition. Let us see the deposition.
Yes, depositions I have given. No, everyone, and there is no eyewitness to the offense.
Without one, my lord, I am guessing, my lord, he is Sumitra Chaudhary.
Sumitra?
Chaudhary, informant.
Yes.
In the year 2022, my marriage was celebrated with deceased Sanatan Chaudhary. Then relevant point 44 lordship say. First wife, namely, first.
Come to the relevant part. You can't read
it.
everything.
Say witchcraft korithala, for that reason, Pradeep, this is the statement. Accept.
Nobody has seen.
Nobody. And leading to discoveries there in respect of that.
What is recovered from him?
No, he was in custody in other case. On the date of occurrence or even prior to that, he was in custody. It is the case as per the charge sheet.
Then I think he's already there in the custody for about 2 years, more than 2 years. 12/9/2022.
23.
23.
More than 1 year.
More than 1 year. What do you say?
This protection is also some antecedents.
Yes, I have filed that, sir.
Antecedent maybe.
Well, that is the evidence.
I don't. Petitioner is an accused in so and so case. The petitioner so and so. The co-accused. Where are the orders? Rahul order you have filed, and what about the other order? Co-accused Rahul. Rahul filed BLAPL number 2228 of 2024, which was allowed by this court by order dated 14/8/2020. Whereas another accused Ramo Raul filed BLAPL 1966 of 24, which was again allowed on 2/9/2022. Allegation is little one. Allegation is the firing. It is alleged, it is alleged against the petitioner that the petitioner's wife has died due to the witchcraft died. The petitioner suspected that the deceased is involved in the killing of his wife by witchcraft, by practicing witchcraft. Therefore, with the help of the other two persons, he has eliminated the disease, eliminated the disease. There is no direct evidence available on record. The petitioner against the petitioner, the disclosure statement leading to is cited by the prosecutor. However, there is nothing is coming on record to show that any kind of recovery has been effected to the affected from the petition. Therefore, substantially, the role of the who is present, those who have been granted bail, is similar to that of intelligence. It is in custody since 12/9/2020. How many witnesses have been examined?
8 witnesses.
Out of?
Out of Jasitam Deji. Take this.
Out of 27 witnesses.
Minus
Out of 27.
28.
28 witnesses. How many witnesses examined?
8 witnesses.
8 witnesses.
27.
Examined. The evidence of the said witnesses they have been examined is also not eliminated. Now, we also not ascribing any substantial role against the petitioner. Petitioner in custody since 12/9/2023 and 12/9/2023. Therefore, and two persons have already been granted bail. Therefore, I'm inclined to enlarge the petition with all conditions. He shall appear before the trial court on his date of hearing without fail in a single day absent in the trial court will entail cancellation of bail. Yes.
Lordship, he is the conspirator.
Huh?
He is the main conspirator.
Sorry?
He is the main conspirator.
He is the main conspirator. Yes.
19.
May I please, Lordship, my lords. Last occasion, Lordship filed the comprehensive affidavit regarding the present petitioner, my lords, and my lord, bail was allowed, but subject to condition that he shall be released on bail, subject to verification of similar type of.
How many cases? How many cases are?
My lord, 5 criminal cases, my lord, against present petitioner, but out of 5, my lord, 1 similar case was against the present petitioner, my lords, and this case was bail, my lords.
Yes, verified.
My lord, I also.
Have you verified?
Yes.
My lord, one case is that is 21B of NDPS.
That is the also order, my lords.
And in the rejection
What?
of
6 gram. In this case?
In this case, 170.60. Sorry, Saturi.
Petitioner has already been admitted to bail by the order dated on 25/9/2024. However, he has not been released from the custody because of the condition imposed by this court. Imposed by this court regarding the verification of the similar type of petitioner pursuant to the order of this court dated 5/11/2024. Petitioner has filed an affidavit inter alia stating as under affidavit para 4. The account for the petitioner submits that the petitioner is alleged to have been involved in Panjpur PS case number 47 of 2024 for alleged offence under section 21B of NDPS. In that case, the petitioner had been enlarged on bail by the order dated 27/3/2024, passed by the coding bench of this court in BLAPL number 2541/2024. It appears in the said case 6.360 gram of brown sugar had been recovered. Petitioner is in custody since
Under custody 11/5/2024 minutes.
11/5/2024.
2024.
2020. Regard being head to the aforementioned, the condition laid down by
No, ये जो present case है.
condition laid down by this court by the order dated 25/9/2024 is relaxed. The petitioners are being released on bail. And the release on bail, subject to verification of any other case. Any other case pending against him, apart from the cases as mentioned. Next.
Yes. 35.
With regard to the item number 1, this observed the postal remark, no such person in this address. My instruction is she has died, so that I have to take.
Counsel for the petitioner
Substitute
submits that the
substitute
opposite party number one.
With regard to 2, my instruction is same address is noting is addressing cannot be located. She is staying in that address.
Submits that insofar as the opposite party number 2 is concerned, she has got instructions that the opposite party number 2 has expired. Insofar as the opposite party number 2 is concerned, she will be taking the press steps. So, please the matter
That
second.
is written, so that may be unutilized copy may be utilized, that may be sent or redirected in the same address.
Requisites may be utilized for issuance of notice on opposite party number 2. Yes, next.
Is 6.
Please, Your Lordship.
Yes, sir.
File a LLM petition for restoration. Because on that date, sir, I was in the court of Honorable Justice Savitri Ratha.
For the reasons stated in the application, the petition is allowed. The CRLM sheet 5210 of 2023 is restored to its original file. Please the matter for hearing. Yes.
37.
Sir, I have filed a IA for dispense with the certified copy. Sir.
Which one?
IN number 36 Miller.
Yes.
IN number 39 of 2024.
Yes.
And file a
It's all right.
interim application.
Yes. Yes. 30.
37.
37. Last order, my lord, kind of a class. 411.
Yeah. Yes.
Yes.
The counsel of the opposite party seeks an adjournment to obtain instruction from the client regarding the compliance of the condition imposed by this court by granting bail.
Clear violation of your lordship's order. My lord, page 17, my lord, paragraph 4, my lord.
Page
17, paragraph 4.
Yes.
Relevant.
17 years, para 4.
Right.
Yes. Counsel for the petitioner on instructions.
1 lakh at the time of and subsequently rest amount.
Yes.
will-
You are supposed to say.
Yes, Lordship. Lordship, kindly have a glance, page 17, para 8, Lordship. Lordship, as per your order, direction to you allow, Lordships allow the prayer of the present petition, Lordship. That is period of detention. Another is cooperate with the investigation, Lordship. Lordship, jo 1 lakh is not mentioned, Lordship. That's why unable
I
to
see
say.
why don't you see this para 4? You
Lordship,
have considered, you said that I'll pay 1 lakh rupees.
No, Lordship.
And that was the premises on the basis of which the bail is granted. Now you
Lordship, mode of payment is not mentioned, Lordship. That
now you pay.
is unable to pay the.
Now you pay after. See, you have made the statement.
There is
Read para 4. Read para 4.
Yes, Lordship, I am already.
And the
reading,
counsel for the petitioner on instruction submits that he would pay all the amount to the informant on installment basis.
Account
To
transaction
begin
was
with,
there.
he will pay 1 lakh rupees.
Yes, Lordship, that is the instruction of the petitioner, Lordship. But say, as per 18, that is mode of payment is not mentioned. That's why Lordship asked for
I'm
the.
saying you pay, mode of payment is 1 lakh rupees you pay first.
Lordship is unable to pay. Lordship will directed to pay. He'll pay Lordship.
Then I'll cancel the bail. For bail, you make all kind of statement. Once bail is granted, then you wriggle out of it.
No,
What
no,
is this?
Lordship. As per
It is
the-
your own statement I recorded. And you persuaded on that basis, I granted the bail. Now today you can't say that I will not pay. What is this? It is not a condition imposed by the court. It is a volunteer statement made by you.
Yes, Lordship, but no.
Had there been a condition, you could have said that yes, it is onerous condition. It is not a condition imposed by the court. Rather, it is a statement made by you.
Lordship, kindly grant on 6 month Lordship, he will pay.
No, I will not. This is not a, I can't, you can't negotiate with this. Then remain in the jail for 6 months. You made a statement. You have to stand by your statement.
Lordship is right, but.
You made a statement in the High Court. You can't get away with that. What is the total amount?
Total amount is, my lord.
What is the allegation total amount?
Yes, 3,84,000. 3,84,000.
3 lakh. Why don't you pay in on
There is a
installment
account-
basis? I'll quash, forget about the bail and all. I'll quash the entire proceeding. Pay the money on installment, finish it up.
Let's say I am taking instruction, he will pay 85,000.
I don't know
But
how we speak to him and pay the entire amount, file a quashing petition, I'll quash it. I'll put it in the first week, okay? First week of simply adjourn. And finish it up, unnecessary, otherwise, yes.
I beg pardon, my lord, on behalf of Mr. K.C. Pradhan, the matter may be taken up after vacation.
Okay, on request, after vacation, yes.
49.
May I please?
Please, your lordship. My lord, matter already settled. In the meantime, opposite party number 2, though noting is there, requisite not filed, but opposite party already appeared and filed affidavit.
After to copy the
Opposite party, you are appearing for opposite party?
Yes, on behalf of Mr. Mahathir.
I'm appearing.
Matter is settled.
Matter already settled, my lord.
Matter only settlement.
What are the allegations?
Allegation is that land dispute, my lord, because of allegation is that they have committed forged sale deeds.
Charge sheet has been filed?
My lord, no charge sheet. Charge sheet.
It's a case of the year 2022.
No charge sheet.
Whether charge sheet has been filed or
No, charge sheet has not been filed.
Yes.
What is it? There are notice notice has been issued to the opposite party.
He is appealing.
But today is come, but that instruction is not with
You
me.
see,
Petitioner twice.
get instruction whether charge sheet has been filed.
Because every time there
Let us understand. Huh?
In all occasions previously there was Arjun. Today he has appeared, my lord. I have to take instruction whether charge sheet has been submitted and the affidavit which he has filed.
Yeah, I don't have any objection. You may take instruction regarding charge sheet, but I don't have.
No, you let him get it.
Right.
So and so appearing on behalf of opposite party number 2, opposite party number 2 information. The petitioner is seeking quashing of the entire proceedings on the ground of settlement. However, the petitioner is not able to ascertain as to whether charge sheet has been filed in this case. Mr. Jena, the counsel will for state that the investigation, release the matter second week. Yes.
Both
Yes. Next 40.
40.
No, please.
Yes,
No,
sir.
file this application for pursuit of the covenant order. Pass with the ground.
What to withdrawal of it?
No. no.
40. Yes, yes.
Passed by the landlord resident Niagara in one session number 21/2022 minor. And it's an annexure 5 minor, the covenant order taken by the landlord property.
Annexure 5?
Annexure 5, page 27.
Yes, sir.
The page 28, the order.
Yes.
Order dated 30 May
Yes,
2022.
yes.
It's the put a fraud already had.
Yes, yes. I read it.
Lost. In this case, and the fact is that matter,
Hmm.
one FIR has lost by the wife. This is a pure family dispute matter.
Hmm.
FIR has lost annexure 1 before the Niagara police station
Yes.
on 21st February 2021.
Hmm.
In same FIR, police was investigated and final file charge sheet.
Yes,
That
you
is false FIR.
filed protest petition. Come to the protest petition.
File the wife matter.
Yes.
Your lordship.
Protest petition. Show me the
And
protest.
see the annexure 3.
24
Yes,
matter.
I'm there.
24 is the protest.
Come to 4.
Your lordship.
What are the allegations? Let's see.
Same allegation. In the FIR, there is allegation.
25 ro effect podi.
25, para 8. Brief of the fact that the complainant.
Where are the statements and 202?
Exactly. Can I file affidavit, your lordship?
Where is that?
Can see my additional affidavit.
Yes. Yes.
Page 6 of the additional affidavit.
Yes.
Lordship.
Yes.
The mother has given the affidavit matter.
Yes.
First, the complainant is my daughter. She has filed this case against her husband, Hon'Ble Kumar Sahu, father-in-law Balakrishna Sahu, and elder brother. My daughter is now staying in our house as the accused person tortured mental and physical. That the occurrence took place 14 months back in the year 2021. On the date of occurrence, that about 1 p.m. It was 1 p.m. in a day question. Kintu FIR day night re.
Cognizance order, you have to just see whether prima facie case is made out or not.
Exactly.
I will not appreciate the evidence.
Can see my daughter there. My daughter shouted her for help.
I read it. Now, what do you say?
My said the FIR is complete false. Therefore, the police investigated and filed the FIR false.
Protest petition filed.
Exactly.
There are allegations are there in the protest petition and is supported by 202 inquiry.
That is false. Therefore, I read the statement.
False. If you appreciate it vis-a-vis the FIR and all, then you may say that it is fault. Can I appreciate it? Can I appreciate the evidence, pre-summoning evidence? Prima facie case is made out, cognizance is taken. I can't appreciate it in 482 proceeding.
498 settle hold.
Can we see the document minor is index para? The police given the injury report. And para last para the self-made. The injury is in
again, I have to appreciate the evidence. I can't appreciate that. That's the whole difficulty. In this proceeding, I can't appreciate. Statements are there. What to do? Wrong, right, whatever. It appears to be a false case, but evidence is recorded. You have to confront them.
Can you see the statement made by the father? Now, father said that nowhere there at the time of.
I know, but those things has to be appreciated. The evidence has to be appreciated, but the fact remains in a complaint, specific allegations are met, and 202 statement in the specific allegations are met. Cognizance is taken. And you want to read me various documents and appreciate those statements. That I can't do it. You file appropriate application for trial court. Huh? The petitioner is seeking quashing of order dated 3/5 passed by Learned SCGM Niagara in ICC case number 25 of 2022. Initially, the FIR was registered against the petitioner by the opposite party number 2. Which was investigated by the police, and a final form was filed on 31/3/2021 inter India, stating that the case is no case is made out from the evidence collected by the police. Being agreed by the same, the opposite party number 2 filed a protest petition being ICC case number 1CC case number 25 of 2022 and 22. The land court below enter into an inquiry under section 202 CRPC, and on the basis of the inquiry and the government made in the complaint petition, complaint of the protest petition, cognizance has been taken. Taken. I find no reason to disagree with the trial court and trial court taking cognizance of the offensive punishable under section so and so. Therefore, I am not inclined to entertain this petition. However, the petitioner is granted liberty to move appropriate applications for the trial court, raising all the points as has been taken in the present proceeding. Besides the other point, and by moving the appropriate application for, at the appropriate stage, if such application is moved, same shall be considered on this day. Yes.
Okay. One.
May I be allowed? The present petition challenges the communist order dated 27/1/2023 manner. And so the last date, that is
Service.
29/8.
Requisites you have not filed.
Lordship is also called for a
Despite notice to opposite party number 2, the petitioner has not filed requisites.
Only within a week.
Huh?
Within a week.
See, that's the problem. Why have you not filed?
After my directly call for a report from the.
not paid.
But requisite you have not filed. It's 1 week time, at least in February.
43.
Yes, for instance, from a petitioner in item number.
Wait,
also
please,
not
ma'am.
used.
I'm appearing for the petitioner, my lords. My senior is supposed to appear in the matter, my lords. He is indisposed today, only today, my lords. If it can be called tomorrow or day after, my lords.
I'm extremely sorry, madam. I have accommodated for many days. It will be difficult for me to accommodate. You will not see me, hear me. Hear him later, pass orders. I have no objection to it.
Only one day, I'm.
No, madam, but several times I have to wait for this.
What is this matter, by the way?
I am submitting. Akshay Kumar Naik.
Let's may pass it over, my lords.
Just a minute. Again, that's the same problem, madam. I am Delhi.
What is the problem?
Let's my senior is not, is indisposed today, my lords. His father's,
I will submit a
his
written.
father's death anniversary
I will
is there.
submit a
That's
written
all.
note. Your lordship may dispose of the matter. After hearing him, I have no objection.
No, piecemeal, see, it is burden on the court only. I have to read everything once again.
Last time also he was arguing. He did not call for his senior.
Let's,
You argue, what is the problem?
look, I'm not supposed
competent
to.
enough to
It's
do
my
it.
senior's brief, my lords.
I'll just pass it over, just see. Read
If
it
I,
and
Passed
try.
over means again it will.
What to do, you tell me.
No,
may list it to tomorrow, my lords.
after it is passed over, he will not be able to come because he will be busy with the sponsor.
One day may be granted, my lords. Tomorrow my senior will appear in the matter and argue, my lords. Only one day.
24th.
Again, I shall have to wait for.
24th, before this side of the petition. Yes. Yes.
হ্যাঁ কালি করুন
It's not possible.
24th আগে হবে না
Let it be 23rd on.
24th হবে না কাହିଁକି
These 2 days, just impossible. 23rd, look. 23rd. Yes. Very difficult. Yes. 23rd.
Great.
But let it be over on that day, closed on that day.
I have no problem. It is the problem
No,
that side.
they are granted time, it will be difficult for them.
And it is made clear that no further adjournment shall be given on any pretext to the either party.
There's an interim order.
As the interim order is the only problem. Otherwise, you would not have.
Trial has been stalled.
Interim order. And I'll vacate the interim order on 23rd. If you ask for adjournment. Yes.
44.
Yes, my lord. In this case, my lord, the tracking report says that the copy has been solved. As per my lord.
For opposite partner 2, I have got the instruction to appear,
Today I will be filing vocal now.
Yes,
So,
notice of
so printed a period for opposite party number 2 and fix time to file counter with links to matter also. Yes.
interim order tax.
Entry mode to continue.
My lordship defer to.
Give a date.
No, my lord, conditional order has been complied.
That 12/11, there is a conditional order. The
20,000 has been deposited.
20,000 for the trial court.
Yes, yes, has been
It was not
deposited. Yes,
that my
yes,
running
yes,
senior.
1 minute, 1
Yes,
minute.
Your Lord.
Yes.
The
44, conditional thila I have deposited, my lord. That may be recorded, my lord.
the condition imposed by the earlier order
12/11,
20,000.
for depositing rupees 20,000 has already been complied. And then counsel for the petition submitted. Already been complied.
Your lordship, I'm for the petitioners. Your lordship, actually inadvertently, we could not file the requisites for issuing notices to the OP number 2.
It has been filed today, ma'am.
Yeah, it has been filed today, your lordship.
The problem is if the interim orders are passed, that is the whole difficulty. That is the reason I don't file. I made it a point that no interim order.
Your lordship, it's an act.
Once you take an interim order, you should go out and file the requisite first. You can't take, I'll vacate the interim order.
Inadvertent slip, your lordship.
I'll vacate the interim order, I'll impose cost.
Just one chance. Your
I'll
lordship.
impose cost.
We have
Just
already
one chance.
filed today, my lord. Lordship,
Whatever, why have you not done? See, the order was passed in 8th of November 2020.
I take the onus, my lord, but the problem is just because this is the last time, my lord.
Yes.
What is the
lordship,
matter?
just one chance.
What is the matter? Let us see.
Your lordship, the matter.
What is the stake of the matter? Oh.
So
These are those matters, your lordship.
NGT order has already
NGT
been.
matters where without making us parties.
The requisites in pursuant to the order dated 8/11/2024 that has not been filed by the petitioner. Therefore,
Have
the
been filed, they are saying.
service on opposite party number 2 could not be effected. Then counsel for the petitioner submit and the requisites have been filed today. Today. Let the notice be served on opposite party number 2 utilizing the requisite file today, subject to petitioner paying 2,000 rupees as a cost to the bar association. Give
Your lordship, kindly, your lordship.
2,000 rupees you pay to the bar only. You are not paying anyone.
No, all good.
Pay. Then only you will understand.
This one
1,000 each.
Young people.
Your lordship, this time, your lordship, kindly, your lordship. I mean, just one part.
1,000, both of you pay 1,000.
Kindly,
500.
this time, your lordship.
500 each. Okay.
Your lordship.
Yes, no question. You at least seniors can escape. Juniors can't escape. You took a stay order, you immediately go and file requisite. How can you leave it like that?
Extremely.
3 months, 2 months. Yes. Pay 500 each.
Interim orders will continue.
Interim order to continue.
In all the cases.
All the.
Grateful, my lord.
Grateful.
There are a series of cases now.
And go and pay 500 rupees each.
Receipt ka file karo. 36.
Yes.
My lord, 36 on behalf of Mr. Rautra, may I?
And I leased it in February then. February.
Yes, my lord, please.
February.
Item 36, my lord, on behalf of Mr. Rautra, may I pray for after vacation? A requisite already filed, notice has gone, but no one has appeared on behalf of the interim order may continue, my lord.
Notice, anybody is appearing?
Notice has gone.
Despite service of notice on opposite party number 2, nobody had entered on behalf of opposite party number 2. Counsel for the petitioner. Why should I write? Nobody is appearing in the interest of justice. I'll adjourn. In the interest of justice, adjourn to so and so, interim order to continue.
Obliged.
47.
My lord, in this, there is a nothing, my lord, because it's not filed for the OP number 2. In fact, there is no OP number 2 in the petition. I think this is wrongly which has been mentioned, my lord. In my petition, there is no OP number 2, my lord.
Also, you have not implemented.
But on that day, you will also directed to serve extra copy. Immediately I served. But that is from the other.
What are you seeking? Quashing?
Quashing your lordship.
My lord, yes, quashing of the proceeding pending before the
Who is the informant? Who is the,
498, 409, 434. Your
who is the informant?
My lord, informant is the department, deputy commissioner transport. Comment, my lord.
408.
And my lord, the FIR written report was of 6/1/2013. And the
Respondent nahi, respondent number 2 notice karayegi. I don't. Then counsel for the petitioner submits.
I
that,
saw the extra copy as per law.
the extra copy of the petition has already been served to the state council on the
On the 11th.
although there is no opposite party number 2 in this particular case, however, inadvertently on 11/11/2024 proceeding in the proceeding test is also notice was directed to the opposite party number 2. Therefore, the officers reported that no declaration is required. Since there was no opposite party number 2, declaration is exactly 5. Exactly 5. Matter and the proceeding dated 11/11/2024 is definitely corrected. Notice is issued to state council. State council so wait notice. Release the matter for it.
Will come, my lord.
He'll give it. Yes.
48.
48, my lord, nothing is already notice for the postal tracking, but
Sorry, my lord, in 48, my lord, I am appearing on behalf of the informant, my lord.
Yes.
On the ground, my lord, filed Quashing application before this honorable court on the ground of earlier one 498 case was initiated in the state of West Bengal. This is the subsequent case, my lord. The case was registered and on assurance to maintain the children as well as wife. That matter was disposed of there in the year of 2015, my lord. Subsequently, just 3 months back, again torture, husband torture. Thereafter, FIR lodged before the local police station and
at Bhubaneswar,
my lord.
petitioner will get
No, they are originally they are from Orissa people.
no West Bengal people.
No. Originally from Orissa, even if wife is
Where all of them were staying there in Bhubaneswar?
West Bengal.
No,
West
no, in
Bengal.
Jatni, mile.
Now, why have you filed the if you are meted with your torture and all, it might have been done there in Kharagpur.
Yes, my lord.
No, occurrence not in Kharagpur. Occurrence occurred in Bhubaneswar, my lord. In the year of 2008,
order was passed.
may I permit to place one?
Minute. Let us. It pertains to date of incident. Let us.
Sorry, my lord.
Date of
Incident, occurrence. Occurrence here. Read the FIR. Let us see. By the way, why don't you settle? We are.
Maybe after vacation, my lord, please just.
Shall I send it to mediation?
Sorry, my lord.
Shall I send it to mediation center?
Yes. Interested to maintain 2 children along with wife. They are unable to maintain themselves also. If no.
Lady interim maintenance paid. Salary will deduct ହେଇଯାଉଛି.
Anyway, you try for a settlement because these are matrimonial disputes.
Chance of settlement is.
Then you will have to suffer. I will not cause. I will not cause.
After vacation, I move it.
No, you have to see. You are the husband. You have to maintain. Why don't you settle? 498A. Why should I cause? I have issued only notice that at least you will sit together and do. And if you say that I will not settle, then face the trial. Whatever may happen, I will not interfere.
After vacation, I assume the instruction never say.
They are not paying not a
I
single
say Bhubaneswar ଆସିକି ରହୁଛି ଅନ୍ୟ ଜଣଙ୍କ
my
ପାଖରେ.
lord.
ମୋର ଚାକିରି ହଉଛି ଖଡଗପୁରରେ.
Whatever you can work it out. These are the dispute. You can very well work it out. If it doesn't happen, then pay something, some maintenance, alimony or something.
Already deducted.
No, my lord, not a single pie, not deducted. Your lordship kindly see order.
See, there is interim order. Either I'll send it to mediation or I'll vacate it because there is opposition.
Mediator at Kharagpur or Kharagpur?
No, here in the High Court. On VC you appear and try and find out. I know. So entered appearance for opposite party number 2, pursuant to the notice dated 8/11/2020. The matter is arising out of a matrimonial dispute. The counsel for the parties conjointly submits that they would explore the possibility of settlement in the mediation. Hence, the matter is referred to High Court Mediation Center, and coordinator is directed to also awaiting the mediation report, leaves the matter also entering out to continue. Yes. Second week of January, third week of January. Meanwhile, you just see anything can happen. Yes.
49. The 49 at 3 p.m.
3 p.m.
The 49 50, with along with the 50. Your lordship. And another 2 matters special.
50.
50 also. 51.
51.
51, my lord. After the vigilance case, my lord. We have filed case for a stay of conviction, my lord. And the allegation, my lord.
No, interview country.
And this case, my lord, what happened? Actual, my lord, the
You are appealing for?
I am for the one of the
Sub-item.
accused, but I have not filed any miscase or anything. He has filed a miscase, that's
Okay.
why it has come.
You also earlier attended, my lord.
He has been dismissed from service.
Yes.
That is, my
No,
lord.
that is nothing to do with this case.
My lord, what happened, my lord?
That is a consequential
It
thing.
is a trap case.
I am interested in this criminal case, whether he is removed from service, how does it make difference? It is a consequential thing. Obviously, if you are convicted, you will be removed from service.
No.
Here is the case, my lord.
You are saying that there is no urgency left now.
No, urgency, my lord.
That when she has been dismissed from service.
No, not dismissed, my lord.
It will be the consequences.
Not dismissed.
She will to stay of conviction.
No, I am not going to stay that.
2016.
You tell me in the appeal if you have a case, I will hear it.
For that is, my lord, I am saying, my lord. The demand acceptance both have not been accepted, my lord. The complainant himself became hostile, my lord. He has not stated anything against the petitioner, my lord. And basing on that, my lord, the conviction cannot be sustained. Demand and acceptance both are absent, my lord. They have stated that the complainant stated that the complainant stated this petitioner, my lord, not demanded anything from him, my lord. On the date of occurrence, when he entered to the office of the present petitioner, there the peon was there, my lord. He gave the money to the peon and peon accepted it. That money, tainted money, recovered from the peon, my lord. Peon has not been accused nor the witness in this case, my lord. And my friend's candidate is Sarpanch, my lord. He has nothing to do also. That is the case. If beyond that, anything, my lord, demand and assessment, my lord, then
is there anything?
That is, my lord.
That whatever he said is correct, then there is nothing.
Your lordship kindly have a glance to paragraph 7 of the
One point you show me, then it needs hearing, then I will.
paragraph 7, your lordship perused, then I
7 up, 7 up, 7 up.
Paragraph 7 of the judgment.
Okay. Okay.
Impugned judgment.
Please read it.
Indisputably, in the year 2005, the accused Mohammed Patra, the present applicant, being a public servant, was working as executive officer from DAW, Jamunapasi, GP under Patna Block, Keonjhar, and the accused Akshay Kumar Naik, being a public servant, was working as Sarpanch of the said GP at that point of time. During their examination under section 313 CRBC, while adducing their evidence, none of the accused persons has in any manner disputed the fact that in the year 2005, the complainant was a chairman, managing committee of Godipokari School, and that as the kitchen room of the same school was in dilapidated condition, there was a resolution by the school management to seek some financial assistance from the GP for reparation of the kitchen room, and that pursuant to their application on 29/7/2005, Dr. Naik issued the work order for ₹30,000 for such reparation. And the complainant executed the said work, and then we then Indian engineers Kushtachandra Sahu passed the bill for an amount of ₹27,800. Further, during their examination under section 330 CRBC, or while adducing the respective evidence, none of the accused persons has seriously disputed the fact that on 21/10/2005, the complainant had approached both the accused persons for payment, and the accused Mohammed, the present applicant, told him that the bond was yet to be received, and that on 5/11/2005, he had again met both the accused persons in their office, and the complainant had went to the GP on 9/11/2005 and that on that the vigilance officers are going to the sale office. So keeping in mind these admitted facts of the case, I want to examine the materials available on record to reach a just a decision of the case. At this juncture, I want to scrutinize the materials available on record regarding prior demand. Your Lordship got it.
Yes, demand, yes.
That is demand of bribe by both the accused persons or any of the accused persons from the complainant prior to 9/11/2005. In this regard, BW4 has adduced evidence to the effect that on 31/10/2005 he had approached both the accused person for his payment. The accused Mamata told him that fund was yet to be received. On 5/11/2005, when he again met both the accused in their office, on that occasion the accused Mamata told him that fund had already been received, but his payment would be made on 8th or 9th November 2005. On hearing the above reply, while he was leaving the office of the executive officer, a peon of the executive officer followed him and he told to receive the payment, he was required to pay some percentage and other miscellaneous.
Where is the demand made by him?
Yes.
There.
That is this petitioner appellant demand.
Show me the evidence of peon.
Your Lordship may kindly have a glance to the
But
evidence.
there is no direct demand made by the appellant.
Yes.
He has said that money has come and you left the house, left the office, and the peon subsequently comes and says that you have to pay the money. Demand is made by the peon.
Demand has not been made by the peon.
That's what is the.
Who is to sanction and pay?
That's a different story. You show me direct evidence whether it
is there.
Oh, show me.
Your Lordship may kindly have a glance.
You read the evidence
Your
of
Lordship will go
informant.
only hear the judgment. Your Lordship will be satisfied.
No. Let us come to the evidence of
Judgment.
Informant.
Title 4.
Your Lordship may kindly talk to page para 12.
Who is the informant?
Title 4, madam.
Gaurav Chandra.
Your Lordship may kindly refer to page paragraph 10.
10 of the. Let us come now and understood it.
If Lordship permit me, I will read out the evidence.
Refer to paragraph 10.
Yes, read it.
During cross-examination of BW4 by the prosecution as per the provision of 154 Indian Evidence Act, he has categorically admitted that he has stated in his complaint filed Exhibit 11 on 5/11/2005 when he made the accused executive officer. Who is she? She is the present appellant. She demanded rupees 2,700 from him.
PW4 said. PW4 said.
Yes.
Let us come to the PW4. Therefore, I am saying. Let us come to PW4. Yes.
PW4. Your Lordship may kindly refer to PW4 to paragraph 2.
Yes.
Your Lordship got it.
Chief to
Chief got it. Evidence no.
Okay, read it.
Is it not?
I just want to get an overall idea.
It is a fact that I have stated in my complaint filed Exhibit 11. He has admitted his own FIR, number 1. That on 5/11/5, I made the accused executive officer, Mamata Moi. She demanded me to pay rupees 2,700 towards the It is also a fact that I have written in the Exhibit 11 that I expressed my inability to pay the said demanded money, and that although I requested her to reduce the demand, she did not agree. It is a fact that I
It
have.
needs hearing, bhaiya.
I will come again. The overhearing utterance of master. Is it not all?
Then appreciation is required. Not that it is simple a case of no demand.
Allow me, madam. Chief Technical. I am the complainant in this case. I know the accused persons. At the relevant time, accused Mamata Mai was working as a VAW cum executive officer of Jamuna Posi, Gram Panchayat, and other accused persons of Akshay Kumar, my friends, guy was a surprise. In the year 2005, I was chairman of the Godi Pokhari ME School managing committee. At the kitchen room of the school was in dilapidated condition. There was a resolution by the school management to seek some financial assistance from the Gram Panchayat for the reparation of the kitchen room. Pursuant to the application on
Satish sir,
Come to the second paragraph. Second paragraph. It is a fact that.
Last three line. Last three line is very important. On 5/11/2005, I again met both the accused persons, their office. On the occasion, the accused Mamata Bhai told me that funds had already been received, but my payment would be made 8 or 9th November 2005. On hearing above reply, while I was leaving the office of the executive officer, a peon of the executive officer followed me and he told me to receive the payment. I was required to pay some percentage and other miscellaneous expenses. The name of the peon is Madan Naik. Then I again went to inside the office. Then in presence of the both accused, the above named peon on making some calculation told me that he to receive my payment.
Examination is all right, but your friend has extracted everything in the cross examination.
No,
Against yourself.
Not itself is there. He became hostile manner.
What happened?
Hostile manner.
No.
Hostile manner.
Hostile.
Here, of the hostile.
It's all right, hostile, but it's all right. Subjected to cross examination. One.
950 Supreme Court Tahsildar Singh case manner. How did that deal with the matter?
You can't discard the evidence now. A specific statement that is a fact that is executive officer demanded 2,700 from me.
And all the witnesses.
So then for it has to be read out. I'll hear it.
On date payments, man.
Date would fix karo date first week.
Second week.
Second week Tuesday.
Second week रे छुट्टी अछि 3 दिन छुट्टी मकर संक्रांति से आ गोटे छुट्टी
तो बारिपदा लोक आमे जीवानी मकरा हमर कोन अछि
जीवन हाई कोर्ट छुट्टी तमे करिवो हाई कोर्ट छुट्टी तमे के का
टिके रहि कि देबो डेट देखि कि
थर्ड वीक ऑफ जनवरी
I will adjust and give it so that
That fix so that
we'll fix the date. Now I had a
past explanation Tahsildar Singh 1954 Supreme Court manner.
so a demand goes acceptance they'll read 20. You
20 has not rebutted by them.
The 20 also should which is a trap case.
Where do I figure? It's let's assume for the sake of argument demand by him and paid to him also.
Paid to peon.
So where do I figure manner? I think the serpent
Payment was made
head
through
of the
him.
office. So everything in my name manner. Head of the office serpent.
Neither let us see what is the evidence against him.
Neither will be satisfied. Payment has been made through him to and she both were present and payment was made through him.
Do you have any direct evidence of demand?
No.
Nothing.
Yes. It is
Peon, let us see the peons.
Peon have not made any accused manner. Before your lordship is that the complainant has proved his FIR. In the FIR, he has described everything else. He has proved his signature. And in the statement, in the chief, as well as 154 evidence.
Demand by peon, recovery from peon.
Demand by these particular accused persons, both of them.
There are direct decisions outside.
But who has accepted peon only?
No. This servant received in presence of Mamata Moi.
That is not.
What is the phenolphthalein test for the both of them?
Both of them were present.
Present no.
Received by serpents.
Phenolphthalein.
ये ताको बढ़ाई देला पर अच्छी केमिकल है your lordship
Except peon कार नहीं किंतु peon से accuse करना नहीं witness करना
Argument. Extempo argument will not do.
your lordship
Study manner.
Extempo to get an overall idea.
Exhibit 14 if your lordship go
It will not take more than 10 minutes.
Exactly.
Not more than 10 minutes. You show me. I understood. PW4 you have read it out. Show me the testimony of the peon. Everything will be clear.
No.
Neither peon examined manner, not witness nor accused.
PW6, PW8, PW9.
Not accused.
They are not cited as accused or cited as witness.
And your lordship is very much aware about the recent decision of this Sita Soren versus Union of India.
Sita MP.
They are not Sita Soren, they are common man.
It has been described.
You have not examined that peon who is the backbone of your case.
From whom the tender money recovered?
Your lordship will be satisfied.
We'll see. Okay.
Let I pray that the
I will only suggest you please prepare a written note. Give me. I'll take only 5-10 minutes and finish
Exactly,
it.
and the chemical examination report and this preparation and detection report are not available if they are having with the same.
You speak and give me so that I can. TCR is there. You can take pen drive. Take the pen drive, prepare the written note, give. Let it be parted, huh? Let it be treated as a parted. 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 Parted, the further argument, please on such and such day. And the parties are directed to file short written note. Short written. Short written.
Exactly. Let's say item 52, item 2. Let's say we don't have the paper book, let's say we'll attend the paper book. That should be for as soon as hearing this. Time and again.
Time and again adjournment has been granted. Lordship knows, my lords.
Who are you?
For in sub item 1. I'm always coming prepared, my lords. My lords.
You are friend only.
Sub item 2. My lords. Sub item 2 Rachandi. But many times, my lords, adjournment has already been granted. Still then, my lords.
What can I do? Your friend co-accused with you. Why don't you speak to him and give it whatever he doesn't have? Paper book and all.
Last occasion, my lords, I ratre call kari bhi koitli aaj kachi boli.
See, the prosecution is not asking time.
Yes, my lords. Time and again, they have also asked for time.
No, they will not ask. You get ready yourself.
My lords.
Both of you should get ready.
My lords prepare ke asti puri feri ki jauchu. Maine 5 pata dalani.
Ye co-accused is asking for adjournment. Connected appeal. You give the paper book, whatever you have prepared, give it to him so that.
My lords, fixed a date. My lords, may fix a date.
He will fix a date.
And my lords, pass order that say now further adjournment, my lords. Because see, the problem is the appellant's wife and children, the appellant is dead. The wife and children, they are suffering because pensionary benefits and all they are not getting. So, someone abhi chauliya ko bhi bhari haran ho chahe. So, sethi bhi
Just see, take all these relevant papers and prepare yourself. Okay. Yes, sir.
Item 65.
50?
5.
Yes.
Well, in 55, last occasion, remember, I asked for the, I prayed for the NCA. No court records. There are certain things.
Call for 55, call for TCR.
I have asked for the certified copy of that order.
No, I am asking for TCR. Thereafter you will take. Ask for TCR.
Fix the date.
Yes. Call for.
There is a holiday in between.
He will fix the date. Okay.
I say my lord, 53 your lordship, because old matter your lordship said is not.
I'll adjourn it, but I'll adjust the date and do it.
That's right. 63. There is only a typographical error.
Hmm?
Instead of 2023.
53. Oh, the typo error. Oh, 53 allowed. Yes. $66. Mediation paid.
ଆଉ ଗୋଟେ ପ୍ରେୟାର ଥିଲା କାଲି ତ ସେ ମେଟରଟା ଆସିବ ସେ ଯୋଉ ମେଡିକାଲ ଆଜି ଆସିବା କଥା ଆସିପାରିଲେ ସେ ଯୋଉ ଇଣ୍ଟରିମ୍ ବେଲ୍ ସାର୍ ଅପରେସନ ଫିକ୍ସ ହେଇଛି ମୁଁ ଗୋଟେ ୱାର୍ଡ ଯଦି ହେଇପାରିବ ଟିକେ ଟପ୍ ଅଫ୍ ଦି ଲିଷ୍ଟ ରହିଲା वी कैन टेक एडवांटेज
I'll take it up. Yes. Which matter?
That their students matter, my lord.
70.
My lord, senior is there and state also there.
Yes.
70.
Yes. My lord, is a case where the students are demonstrated in front of the.
What is the stage of investigation?
Now this informant deposed herself. I don't know. That copy has provided the court, also the state council. So now the leave to the state council to submit what is the issue as regard to this commencement of trial. One minor is there, he is acquitted, and other accused are on the trial. During the trial, further court can interfere not. This is the question of law, lordship raised it. In this regard, I have given a judgment of this Honorable Supreme Court. In that case, Supreme Court say that this court can, High Court can interfere and pass necessary order. That's it. Let's see, may come to the first page order. After last line. After investigation, charge sheet was filed, and in this charge sheet, names of the appellants were also included. The appellants at that stage filed petition under section 482 of the CRPC on 1973 CRPC for quashing of the charge sheet against them. The High Court rejected the petition by order dated 22/4/2016 only on the ground that the trial in the case of has been begun, and therefore the High Court would not have interfere with the said process. Then obviously given that I am coming to the last paragraph, that in view of the aforesaid stand taken by the complaint herself, we see no justifiable.
There are 498 cases.
Yes.
Where the informant has said that
here is the case.
anger I have
Yes.
registered.
Here is the case. The president himself lodged the affair.
Show me that.
Yes.
Where is that acquittal order for the
minor this
Yes.
It's not on record. Last occasion, my lord asked us to file this deposition copy of the informant. That I filed. That was not an issue. What I am saying that what my learned friend senior has submitted that this is because it's under this trial, the court should not interfere. The matter should be remitted back to the trial court for education. Our submission is that once the informant herself submitted that I don't know, and thereafter nothing is left.
Where is that? Where is that?
That is reposition Lordship Mercy. That is
Is PW?
Is PW. Let me see. That is PW1, DW1.
Yes.
I know the informant, Jharna Begum.
Jharna,
She was the president of the Board of Secretary Education. I don't know the accused persons. Only the day of occurrence, we are present at the office by hearing from Novala, and we came to know on the set that found that there was a tussle between some outsider. Some of the outsiders
strike the tube light and damage the tube light fell down on my head and my son and other.
Then cross-examination or CMSC, I don't remember the date of occurrence. No documents were there of the respect of the treatment of the hospital. I have no deputy. There is a agitation of the students because the question paper will leakage. This is the only issue. In the time of the administration agreed with this demonstration of the students and filed a FIR against them. After the filing of FIR, this case was trailing since last so many years, and ultimately the students, one of the students got the government job and filed a first one single law. Another the bunch of students.
What are the evidences against this petition? These petitioners, you tell me. There was a hulla, there was a mob, and all these things are all right. Anybody has taken the name of any one of them?
No.
Show me that.
That is ultimately this the deposition. What
in the deposition nobody says anything about it.
Yes. Not
specific hulla, there was a hulla and there was a mob and all. But anybody has taken the name of these people?
No. Only the FIR.
Yes, what do you say? If there is there any specific allegation, how have you charge sheeted them? These people? On basis of what? Chiranjeevi Nayak, Subrat Sethi, Sasikant Malik, and all these people. About 19 of them.
Yes, sir.
Which witness have taken the name of these people?
None of the witnesses are taken.
Then how have you filed charge sheet? It was a mob.
Yes, sir.
You pick up few names and file the charge sheet. Unless it is attributed to them, these people were there or something of that sort. It is a mob inside the office of someone.
Yes.
Any 161 statement?
No.
How have you filed the charge sheet then? Why have you made them accused then?
Lordship, see the page 73 cognizance order. Order dated.
No, let us see the charge sheet. Whoa. How these people are made accused. Informant doesn't take the name of anyone.
No.
It has taken the name of one of the person.
Show me, sir, that
On the charge sheet,
Ah.
in the FIR itself, with reference to subject cited above, I would like to inform you that today around 12 o'clock, we got information that some members of ADVT are coming to the board office for staging demonstration. Accordingly, we immediately contacted Mangalabad police station. We had not been given any prior notice by the ADVP about this demonstration. Around 12:30 o'clock, about 20 to 25 demonstrators came to the main gate of the office and staged dharna and shouted slogan. After a few minutes, the police personnel came and called the president to go outside and collect the memorandum from the demonstrators. Accordingly, the president and officials of the board went to the main entrance for the purpose. One girl introduced herself, the secretary of the ABVP, namely Priyanka Priyadarshini Malik.
Okay, see,
Handed
her
over
name
the
is there.
memorandum. She is petition number 16.
Okay.
Handed over the memorandum to the president and stated, arguing with the president about the viral question papers in the social media. She did not listen to the replies given by the president and started arguing, and all other members started slogans. Suddenly, the members became violent and formed an unlawful assembly. They accused me and other officials in filthy words. Out of fear, we came inside the office and they started manhandling our staff and security guards present there. But unruly mob forcefully broke open the grill gate of the office, entered inside the room. Thereafter, they created all types of vandalism, and the police staff and security guards and officials.
Yes, and then you have taken the name of only one person.
He claimed to be the secretary and handed over the memorandum.
In memorandum itself.
Only you have identified only one person. It is a mob.
How can I identify any person?
It's all right, but what the police has done? How these 19 people were
The
implicated?
police has investigated and they have given the.
Let us see.
Yes.
What is the investigation? Any CCTV footage, anything?
No, nothing is there. Trial is in progress. At that stage, it's too early for us to say anything about the.
No, but after investigation, you implicate someone, there must be some evidence.
There is
What is the evidence? Let us see, understand that.
Only in the
What is the
Lordship,
basis?
page 67. Page 67.
Yes.
There's a description by the police.
It starts at page 66. On 27 to 18, the complainant, Dr. Jahanara Begum, wife of so-and-so, the president of the board of secondary education, Odisha, Cuttack, presented a written report at the spot, alleging therein that today.
No, this is again the same complaint, huh?
Yes.
The complaint. And during investigation, 67.
Yes.
During investigation, I examined the complainant.
During investigation,
Visited
I
the spot.
examined the complainant, visited the spot and prepared a spot map. I sent the imbued staff of BSc Odisha, namely Srimati Gunarar Mahapatra, Karthikeswar Mahapatra, Pradeep Kumar Mahanti, Pradeep Kumar Mahanti,
So all these people.
Ranjan Mahapatra.
I also sent the injured police report.
To the city hospital, Cuttack. I also sent the individual police officers, namely so-and-so. Who we had, and then additional IAC, Mangalabad PS, and the ASI, Professor Kumar Satpathy of Mangalabad PS, the police hospital, Cuttack, for medical examination and opinion. I received the injury reports of the injured officers of the court office and police officer. The MOs have obeyed. The injuries were simple in nature, caused by hot and blunt force.
Have you recorded the statement of these injured people under 161 statement? Any of the injured?
161 statement of the complainant has been recorded.
No, I am talking about the injured. How anybody has identified these people? Tell me that. What instruction you have to tell me?
Let this matter take up.
And everybody who is associated with the ABVP, you have taken their name.
In the name of students, these people cannot do these
I
things.
can understand, sir, but there should be some material against some. See,
Yes, there
one
are-
Priyanka name you have
Your
taken.
Lordships are right. At the trial stage, this case has come. The case of so many years back, it's 98, and in 2024, this petition has been filed, and in 24, the investigation will be done in this.
But you have deposed, who are the other accused? You have deposed that I don't know anything.
What did I depose? I did not say I don't know anything.
Show me.
Let him
And
show
he is
where I
reading
have
that,
said
which
I have
part,
not
which
known
part?
anything. I am the informant in the case.
Yes.
I do not know.
Where are you reading, sir? PW1.
From the report, sir.
My name is Jamnara Begum. I am the
Yes.
informant of this case. I do not know the accused person.
How do I know the accused persons, man? They are the persons. Yeah.
You are here
No,
identifying-
it's not a personal animosity. It is a case
Yes,
where
that I
some
understand.
people came to my office and
On the
attacked
day
me.
we-
How do I know?
by the
I
hearing.
was the president of the Court of Second Execution from 2017 to 2019. The occurrence took place on 27th February 2018. On that day, we got information that some of the students belonging to ABVP.
Yes, that's the problem. You have also not identified. Obviously, you can't identify.
How can I? How-
Yes, that's right. What else then?
In a case under 307, there's so many injuries, so many injury reports, and say breaking of the.
What I'm trying.
Those things the prosecution will produce, my lord.
You tell me against all the 19 accused,
What are the specific allegations?
which injured has
And
taken name
this
of
is-
whom?
This is not a simple offense against a person, my lord.
I understand.
307 is against the society.
I understand.
307 is made out because of the political vendetta. You are selling out the question paper, that's why this question is coming.
Politics will come here.
Yes.
See, there was a
Selling the question
Don't say
paper.
something which is not in the-
That's why
Educationally, there was a move. There is no doubt.
There is a move, admittedly.
And-
We are admitting that we are in move. We are admitting that we are demonstrating. It is not that the way they are make out the yes, we are
And there is-
assaulted anybody without injury.
So there are injured persons.
No, my lord, there is no injury. That's why the court.
No, there are injured persons.
Again, I'm reading my.
No. 67, if you see, the name of injured persons are there.
Yes.
I just want to know whether those injured persons have taken name of anyone else.
Exactly. That is not
If
there.
they have not
That's what I'm
taken,
saying.
then these people have to be out. As simple as that.
My lord, in this case, what is required is that there was a group and these persons were present, number one. Their motorcycles, their other things were seized and they were given in Jima. It's not that there is absolutely no material that they were not present. They were present. Once they are present, in an offense of this nature, naming each person is not possible. How
Their
can I name?
presence, there are
10
presence
people
has from
come
there.
by-
Some corroborative evidence relating to their presence has to be found out.
Once their presence is established, it is for them to say that we were not involved in the crime.
That's what you
That's
have
right,
to
my
say.
lord. So
You
it's-
prepare, you have
it-
to, you can't just simply read the charge sheet for one page and can't argue. You have to tell me who are there and what are the evidence, their presence.
Then let me keep it tomorrow.
What are the evidence you have collected regarding their presence?
Decide the date. Who did that?
It may so happen.
Keep it tomorrow.
It may so happen.
That's not the dominant of here.
It may so happen that out of 19, there may be 2-3 people, those who are presence is proved. They have to face the trial. If the people, those who are presence is also not proved in the charge sheet, and name merely because they are the office bearer or sympathizer of ABVP and all, you can't prosecute them. Young
Let him
people.
produce
So I'll
entire
call
case record.
for them. That's what the
May I pray one thing?
yes.
May I pray one thing? Lordship will keep it tomorrow. Because poor adjournment they have taken.
Day after
Both
tomorrow.
sides.
Day after
No,
tomorrow.
I have not taken any adjournment.
I'm not giving
I am
him.
without giving his
I have been through
I am going to write.
preparing and opposing.
Yes, if this associate has intimate me, please come and take. You take a time and go.
No, not like that.
Yes.
Your
This is the
lordship,
facts.
your lordship will kindly appreciate what has happened in this case.
Madam,
friend
what
has-
I'm saying.
No, let me.
Once a senior counsel,
No,
as
let me
being a
very
senior
clear.
counsel,
No,
you must very fair to the
No,
case.
I am fair. I am never unfair. That is my reputation also.
let us-
Kindly listen 1 second, my lord. My learned friend has made a mention before this honorable court, which fell from your lordship's mouth, saying that if notice is given, board authorities will appear, they will concede, and there was a compromise. Because of that, your lordships have directed the matter to be taken up. On the next day, when I appeared, your lordship said these things, and I said that I do not know anything about the compromise. If there is anything, I will have to find out from the office. This is what I have said. Is it taking an adjournment?
My lord, last occasion,
All right,
it was
not waste.
yes. 1 minute, Mr. Patil, let us not waste the time. Oh, he has to now answer.
Yes, that's why I'm
And
saying.
I'm putting it day after tomorrow, because 1 day in between I'll give you. Please prepare the chart and come. Don't give the general story.
Your lordship direct them to produce the entire record along
And,
with the
and
seizure lists and
he says seizure list also. Suppose somebody has gone there, his bike is parked.
And
That
he's
is
taken
your
on
seat.
Jima.
His presence may be indirectly proved. Those kind of things also, what are the materials? At least the people, those who are not there at all, I'll have to cause, because there are young people, their career is at stake. We can't.
Your lordship
take things.
also is considering the stage when the proceeding is being considered here. The trial is going on, evidence will be adduced there, and there is no question of putting pressure on the
More
court.
evidence after this
That's not
question
putting-
examined,
not a
and
matter
he
of
has said that.
See, these people are young people and they are students. And something might have happened. All the college premises and all these things happen. We can't jeopardize their entire career. So that is the idea of examining. At this
The
time.
idea, my submission will be otherwise. I will submit that students should behave like a student. Otherwise, it should be a lesson to everyone in the future to come and maintain the discipline in the society. Society cannot be left to.
You are absolutely correct. There you are absolutely correct.
What I'm praying, my lord, what I'm praying, that the prosecution come with all the documents in instruction and appraise the court. Also, we will whatever document they require to be examined, they'll examine and give a note of submission in this regard to the court.
Yes, he will prepare the note. He will
Yes.
prepare the note. That's the idea.
It will helpful to the
Prepare
court.
the,
and,
I'll coordinate
yes.
that with the document
Yes,
which is
yes.
submitted.
Then it's going to be again. It will be.
Yes.
This is my only prayer.
Yes, yes.
Oblige.
Put little more efforts.
Can I pray, my lord? It's 2 p.m. the day after tomorrow.
Yes.
2 p.m.
Put little more efforts, okay? Because, yes.
And the last occasion, my lord of the director to the government council manager to place compliance report, file an affidavit, my lord. But they have not filed. They have not fully complied. My lord.
There is a change of guard now. There is a change. And yes, Mr. Jana,
My lord,
do you have any instruction in this?
as per my instruction that has been complied, but my lord,
No, he has some problem, therefore I have adjourned it. Just look into it. Because now there is a change of guard. Okay.
Last order, my lord, final guard.
I will go through that.
Yes. Mr. Jana, Learned Counsel for the petition seeks an adjournment. Because of the change of the state council, he has to go through the papers and address the basically.
My lord, so far as the government has filed a document, my lord, on that basis, my lord.
I have adjourned, let him read it, let him read him.
And I have filed objection, my lord.
Let him read, give all the papers, yes.
That is a noting, my lord.
Yes, 56.
Last date.
50?
I
Okay.
The date may be fixed.
Oh, date will be fixed, yes. 50? 56.
After vacation, my lord, after vacation.
56. Yes, there was a
Investigation or further investigation, the case is the most important.
put it in the second week of January. Okay, on request of Mr. Mishra. Second week. Yes.
Maybe
You may put it first week. Third week, let it be third. Okay. Interim order to continue. Yes. There is no interim order.
in that day previously you also had, I will look into, I made a mention that they let the imprimor that yes, while it was splitted. See, imprimor was not part, they considered a frame charge.
Okay. We'll see.
Okay.
Third week, huh? Yes.
58.
Meeting at 3:30.
What is 3:30? What is this matter?
Matter will be taken up at 3:30.
Yes.
62.
May I please your lordship? My lord, kindly see order dated 22/2024.
22/2024.
Your lordship, petitioners along with the informant appeared before the IAC Chandpur and filed joint affidavit. On dated
Yes.
Your Lordship, in the meantime, they have not appeared. So can be taken up after vacation this matter.
No, no. What happened thereafter? There is understanding. It can't be pending like this. क्या लिखा था? Mr. Pradhan and Counsel for the petition submit that the parties in all the three matters have settled their dispute amicably. In all the three cases, the entire village are involved with. Therefore, it would be practically not possible for him to make the petition of peer report. Yes. What have they appeared before IO?
Yeah. They have to file the affidavit of joint affidavit.
Have they filed it before IO?
No,
Have you
I
filed it
think-
before IO?
They have appeared before the IAC.
When have they appeared? When have they appeared?
Appeared on the day.
Huh? Yes.
I'll take instruction on that.
1, 2, 3, 4 cases. You said that you have settled the dispute. There are many people involved. Therefore, I say that you file joint affidavit, go and appear before IO. IO will verify and file a report. Where is the report? And this order was passed in February. I can't wait for years together. If you have not settled the dispute, not settled the dispute, what to do?
Your Lordship, fix your date. I'll produce the.
Yes. Mr. Vishal, you haven't taken any instruction or not?
I have to take instruction with regard to whether.
See, 1 year, what is this going on?
Yes, ma'am.
See, February, this order was passed.
February order was passed.
And the no instructions so far. Please see the before. First weekly forget. Entry mode is not there, sir. No entry mode.
63.
Hmm? 2012. Up to 2012 mediation. First week or two. Mediation is still going on. Awaiting mediation report, please.
Counter affidavit filed by the OP.
Mediation is going on.
Yes.
Date is fixed, huh? What is it? You said mediation is going on?
Number 2. And sir, counter affidavit is already been filed.
Okay, it's going on.
File.
My lord.
Yes.
Yes, ma'am. My lord, in this criminal miscase, my lord, the petitioners are challenging the cognizance order taken in CMC 602 of 2023, my lord, that is domestic violence proceeding, which is pending before the learned GMFC COC 2 Bhubaneswar, my lord. Cognizance. And the fact of the case, my lord, one, the wife, the agreed person, filed a CMC 602 of 2023, filed seeking appropriate protection in terms of section 18, 19, 20, 22 of the Act, and has been preferred against the petition number 1, that is respondent number 1, husband, as well as other in-laws, father-in-law, mother-in-law, sister-in-laws, and husband of sister-in-laws also. And allegation has been made in that some demand of dowry has been made by the petitioners, and so many allegation that is not no specific allegation has been made. Only that my submission is the normal wear and tear of life, my lord. And after that, the learned JMFC COC 2 has taken cognizance on 12/10/2023 and issued summon to 6 summoned on 6/11/2023 to the petition. matter.
Party number 2, just see service. Yes.
I'm waiting for the.
Yes, madam. And
That first and foremost, this petition is completely misconceived, misconstrued and misinterpreted because there is no order of cognizance. Section 12, got a file here. This is only an order.
No, yes, I understand.
It's a summons to respond.
Yes.
And moreover, I think if the act is to be seen, section 12 or reliefs are all civil in nature. The only pecuniary, that is punishable is section 31. Eguda jodi violate hobo, section 31 is punishable.
Yes.
So there is no order of cognizance which can be challenged in this before a lordship. So this is only and there's a I am armed with a order of the Honorable Apex Court which will make the situation very clear. Only a paragraph.
There is no question of settlement.
This is not a complaint under section 2.
No, I understand settlement. I have issued notice only because of that.
Settlement because as it is, this is not maintainable. Cognizance order in 9. This
and I have annexed 2 series matter. That is the order.
No. You
And
the fact that you're challenging an order of
let-
cognizance, annexure 2 does that.
let the prisoner seeking quashing of the domestic violence proceeding matter.
Hey, paribani again.
It is CMC.
It is not a criminal.
I have taken 20 grounds, madam. Let me complete. I'll kindly hear me, my lord. I have taken 20 grounds.
It is not a criminal proceeding, my lords. These are all civil consequences.
The very fact that
But
you have
punishment is there, na, for
No.
1 minute. The very fact that you have 20 ground
yes, madam.
itself is good for you to go and contest it.
My lord,
In this proceeding, I can't evaluate every ground. It is no application there and satisfied.
I will submit one ground, madam. Let me submit one ground, my lord. This petition, this CMC is not maintainable. In this limitation ground is there, my lord. Kindly see. Let me complete it. I know you are a senior counsel.
Not like that. Not like
You are
that.
so much experienced.
I'm not
Let me submit. In this process, I will learn also.
No, I'm sorry. I was not.
You are discouraging me. Well, let kindly see for a moment.
Yes.
Yes. Let the ground number 3, page 10.
Okay.
Page 10, madam.
Yes.
For that, the domestic violence proceeding in CMC petition is liable to be quashed on the ground of limitation as section 2032 of the Act read with 15(6) of the domestic violence rules made the provision of criminal procedure code applicable. As such, the limitation period as prescribed under section 468 of the CRPC will apply. The kindly see for a moment that section 28 of the DV, the Domestic Violence Act matter.
Yes, read it. Read it.
Well, the 28 speaks about procedure. 1. Save as otherwise provided in this act, all proceedings under section 12, 18, 19, 20, 21, 22 and 23 and offences under section 31 shall be governed by the provisions of the Code of Criminal Procedure and Settlement. Now, kindly see that 31. 31 speaks about the penalty for breach of protection order by respondent. That 1, a breach of protection order or of an interim protection order by the respondent shall be an offence.
There should be an order first.
Yes, ma'am.
Where is the order? Where is the 31 order?
That order is yet to come.
That is what it is saying.
Well,
unless there is an order, you can't say that. There should be an order. And if it is violated, then the criminal offences attracts. Did you follow? That's what the case is.
But some Supreme Court judgment is there, my lord. That has been
must be arising out of an order under 31. Those cases are. Have you seen this judgment which
I think
madam is?
No.
Will you prepare it?
Yes,
sir.
I'll go through it.
Trying a bigger proposition. You better take this judgment. I just take them and keep it in.
Very specifically, paragraph 20, 21.
Later. He has research in that subject. Let him do it. Okay. Second week. Simply. Just see this judgment.
Yes.
Okay.
এটা আপনাকে দিয়ে দিই। এটা দাও।
No, we don't have files.
Acha.
So, yes. Just read that judgment and try to discuss if you can.
Yes.
Otherwise, you don't have a case.
Well.
Or otherwise, you can very well withdraw this petition, move appropriate application for the trial court, raise all these points.
Right. That is.
Let trial court deal with it.
My lord, as
It's
no,
only summoning.
my
You
lord, no
don't
stay order
file
is
your objection.
but in this process, these guys will suffer a lot. This will be abuse of process of.
And after 2
court
months,
mass.
I'll pass the same order again. 2 months you will suffer.
My lord.
Think over it.
Right.
Okay. Think over it. Yes.
67.
Summons are issued means you go and you prevent the court from passing any 31 order. Then you know.
The cause of action arises.
As because no stay order was there, the proceeding was going on, and I have filed my.
By the time 31 order will be made, what is the use? Anyway, you try. Okay.
67.
Deeply
Yes.
oppressed. Okay.
Chutri Paras.
Lordship, I am appearing virtually in 67. The mediation failed, Lordship.
Failed.
Lordship. And Lordship may allow me a week time to file additional document in this.
Mediation failed. Mediation,
Yes,
the matter was referred to mediation.
Counter affidavit file.
Wide order dated
I have already.
29/8/2024. However, the mediation is unsuccessful. Leaves the matter for him.
I
My
have
lord,
filed
he said that he has filed
by the
counter
opposite party number 2.
not been served.
Sorry?
So he stated that he has filed counter affidavit, but I have not been
Already
served.
tried?
Yes, already.
I'll give you a copy to me. Huh?
It's on.
Yes.
68.
68, I'm appearing through VC
Party.
on behalf of the petitioner.
I'll be test Dhilama.
Item number 68, my lords, I'm appearing through VC on behalf of the petitioner, my lords.
Yes.
For item number 68, on behalf of the petitioner, I'm appearing through VC, my lords.
Yes, sir.
In this petition, the petitioner has challenged the order dated 5th of April 2024, passed by the learned trial court on 1cc case number 270/2028, by which order the learned trial court rejected the prayer of the petitioner to send the disputed checks together with the specimen handwritings to the handwriting expert, to the FSL, for
You
opinion
are
of handwriting.
Respondent for opposite party, my lord.
You file the counter.
Not
Counter
filed.
has been-
What do you want?
Today I'm appearing, my lord. On behalf of Mr. Pradhan. Mr. Pradhan joined the government panel. Today I'm appearing and I filed with Dhinama. I'll file it the counter, my lord.
My lords, let the petition, I have a humble submission. May I be heard, my lords? I have a humble submission. I may be heard, my lords. I have a simple submission, my lords.
No,
Let
he
the-
has entered appearance.
No, I'm just asking, my lords. Please hear me out, my lords. I'm just asking, since this case pertains to the year 2018, and it was a continuous submission on behalf of the OP that the petitioner has approached this honorable court in order to linger the proceeding. So let this petition be disposed of in accordance to the judicial dicta passed by the Honorable Apex Court in Murari Lal versus State of MP, 1980, 1 SCC 704, Lalit Popli versus Canara Bank and another 2003, 3 SCC 583. And let the petitioner be granted liberty to approach the court below by filing a petition under Section 73 of the Indian Evidence Act. In 73 Indian Evidence Act gives ample power to the learned court below, to a trial court, to examine the admitted handwritings. It gives ample power and jurisdiction to the honorable court.
That is page 45, my lord. The order was challenged. That is page 45 of the petition, my lord.
Yes.
Instead of let the case be disposed of on that grounds, my lords. It will serve the purpose. I need the handwritings and the writings on the checks to be examined. The court has ample power to examine that. The Honorable Apex Court says that. And recently, the Honorable Apex Court in Manorama Naik versus State of Orissa and another, in criminal appeal number 423 of 2023, disposed of on 14th of March 2022, has also observed saying that the court has ample power to examine the handwritings and the writings of a document in accordance with the provision of Section 40.
Have you seen true judgment is relying upon?
My lord, my humble submission, my lord. The trial court disposed of the case
on the basis of the judgment glad of the passes Apex Court, my lord, as the Oriental Bank of Commerce versus Pradhan Prabodh Kumar theory, and also the Orient and the Birsing versus Mukesh Kumar, and Raj Kishore and Augustus Jabbar. That is Apex Court order, my lord. That is in past year 22, my lord. Is the order in force, my lord. The matter is, my lord, both the parties appear, examine and cross-examine, matters pending for argument. At the time the petition filed for seeking the direction to send the check for FSL. My humble submission, my lord, let them appear in the argument and the judgment pass.
That would be, but what about his prayer? He's relying upon two judgment, 2007 2 SEC 528, Kalyani Vaskar judgment. Have you seen it?
I'm
relying on Murari Lal Mas.
These are the latest judgment.
And he's relying upon Murari Lal also.
Let the matter come and last week, my lord, I will.
This would serve the purpose, my lords. Why honestly drag the matter, my lords? If there is an option, we can choose that option, and it is best suitable for both the parties. The court, the learned court below, has ample power and jurisdiction.
But he has a right to at least read the file and address the court. He today only is entering appearance.
My lords,
The earlier 1 minute, the earlier counsel now is representing the state. He can't appear. That's what he says.
My lords, but the case has not been stayed till date. The case has not been stayed. At least then, by that time, the trial may be stayed, my lords.
And it's an adjournment. It's an adjournment for 3 weeks. Yes.
At least by that date, my lord, by that time, the trial may kindly be stayed. The trial may kindly be stayed, my lords.
Yes.
The trial may kindly be stayed.
First week of January.
By that time, the trial may kindly be stayed. There is an IA
No,
pending.
138 case cannot be stayed like this.
My lord, but the trial is going on, my lords. It is not on fixed for argument.
Yes.
May I please, my lord, item 69, my lord. Here I'm challenging the entire complaint proceeding.
Delivered. Item delivered.
Yes.
You are appearing?
My lord, for OP2.
He is appearing. It's all right. Yes.
My lord, here in a case, my lord, the entire case is civil in nature. Accordingly, my lord, a criminal proceeding cannot be commenced. On that ground, I am arguing, my lord. Herein, what has happened, my lord, the informant owned 3 trucks and 2 trucks has been transferred in the name of the present petition number 1 and 2.
Yes.
And my lord, they have filed a written complaint before the learned Chandikol JMFC, and pursuant to that, FIR has been registered. During the course of investigation, investigative officer came to a conclusion that the informant has given a self-declaration before RTO, and accordingly ownership has been transferred. But however, what has happened when the final form has been submitted before the learned court below conducted an inquiry under section 202. Therein only by simply recording 2 to 3 statements of the informant and his father and his uncle, learned court below has taken cognizance of the matter under section 402, my lord. Herein, my lord, the self-declaration which has been given by the informant before the RTO, that has not been disputed. Under what ground they have given, it is completely comes under civil in nature. If that covenant is still in existence, then they must be filing, if there is an issue, they must file a civil proceeding before the court in session. And accordingly, matter.
Where is that?
I'm challenging the cognizance order, matter.
No, cognizance is all right. Where is that document?
That document, my lord, certainly I have not enclosed, my lord.
That is your whole case. You are arguing on that document. You don't have that.
But in charge sheet, they have written it.
No, you show me that document. That your entire case is revolving over that document.
Yes, my lord.
You say that the document is enforceable under civil
yes,
page
proceeding.
28, page 28, the statement of the informant. On the basis of that,
I understand it. But he says that
petition was filed. Protest was converted to complaint.
I know that.
Yes.
That I know. This much I know. But what he says that you have given an undertaking by way of a document before RTO.
Yes, ma'am.
It has been fraudulently for refinancing petition. Actually, what happened, my lord? The petition.
Where have you said that?
My lord,
refinancing
my
it
lord,
has-
my lord, madam, 1 minute. The petition, the opposite part number 2 is a handicapped and the resident of Bhadrak district. And the petitioner is the resident of Jajpur district, my lord. Petitioner is the resident of Jajpur district of Balichandrapur. I filed a case before the IIC Balichandrapur. But what happened? Perhaps he has gained over because the OP2 is the handicapped person and is residing in Bhadrak. Said police file.
All these things are neither here nor there.
Just
You
one
show me the
Yes,
protest
one
petition
second.
and the statement.
Police filed a charge sheet. I filed a protest petition. And consider.
I understand. Show me the protest petition and 202 statement. Any case is made out or not, I'll see. Why all this story? I am not relevant.
What I pray, my lord, the entire it is a issue regarding
So
consideration,
we-
my lord.
Why don't you understand? You are challenging a cognizance order
Yes, my lord.
taken in a protest petition.
Yes.
Show me the protest petition and 202 statement. That's all.
Yes. What then, my lord? What I pray?
All the story will not cut any
Yes,
eyes.
my lord. What
Show
I-
me that
My
statement.
lord, page 28, the statement of the informant is the part of the protest petition. It will lordship desire to say.
That is no way of doing it.
Yes.
Cognizance order you are challenging
Yes, my
on
lord.
a protest petition, neither the
by-
protest petition,
Yes,
not
giving him
202
liberty
statement.
to raise all this point before the
You
court.
haven't filed anything unnecessary wasting time.
What my
You
lord?
raise all these points before.
No,
Like that.
pardon me, my lord. This self-declaration which I'm asking, my lord, I pray only 1 week time, my lord. Next date, my lord, I will submit before this honorable
Why have
court,
you
my lord.
filed this kind of petition? Then you.
My lord, I have asked for this, my lord, but certainly
Where
this
is
document,
202 statement?
this is my lord, I am with me, my lord.
Where is the protest petition?
I'll file, my lord.
Cognizance is taken where in the protest petition?
Yes,
And
my lord.
202 statement?
202 statements.
Where are those documents? You are challenging cognizance order without filing those things.
My lord,
Unnecessary wasting time.
my lord, I will
don't
file.
understand.
Say that
What I
We
pray, my
deleted
lord.
deleted in February last. Do whatever. There is no
The
statement.
lordship may dispose of giving liberty to him to dispose all this point before.
I'll file.
That's what I'm suggesting.
No, my lord, I will file all those documents accordingly. There is no.
I will
stay.
give
This
you
is not-
liberty. You
Yes,
can raise all these points before trial
No,
court, remove application.
No, the entire my ground itself is it is a civil in nature. It cannot run in the complaint case. No. That
I will quash the entire criminal proceeding on the basis of your oral statement.
No, my lord, I'll file all the document, my lord. That is
No
not-
document is filed.
I'll file, my lord. I was not having in that position. I'll file, my lord.
Yes. Put it in February last week.
Hello, please.
71.
My lord, last occasion, my lord, my brother taken time. I have filed a challenge the counter FIR. I have in first I have filed a FIR. Then they file against me a counter FIR. I have challenged the counter FIR. Then my learned friend stated that it can be compromised. I'll go talk the client.
Yes.
After vacation, compromise.
After vacation, you will settle.
After vacation.
Second week. Yes.
Oblige, my lord.
72.
22, my lord. The informant filed the affidavit, my lord. Informant as well as the victim.
Yes.
Filed the affidavit, my lord. Both informant as well as the victim.
Where are they?
My today.
What are you seeking by the?
Because the 311 petition has been rejected for victim and informant.
311.
311.
Yes. Show me.
Page 18, my lord. 17/5/2024. Page 18.
80. Yes, I'm there.
In the meantime, matter has been settled, my lord. Appear.
What is the age of this boy?
Boy,
20.
my lord.
Girl is 19.
20.
What? Yes. What is the terms of settlement?
Well, in the meantime, victim is already married. Is a blessing a child, my lord. And in that way, she is not proceed to this case, my lord. In that ground, I have submitted the affidavit, my lord.
What do you say?
Lordship, may kindly glance at page 24.
24.
Yes, sir.
Yes.
The second part.
Yes. Yes. Read it.
This is the rejection order of the learned tribe.
Thereafter they have settled the issue.
Yes, sir, they have settled, but Lordship, may tomorrow to keep that.
What I'll say is I'll set aside this order. I'll give them liberty to move press application in view of the changes saying it happens.
Yes, ma'am.
Do it because see the problem is in the ground of settlement I can't pass it. So they've
Observing that.
yes.
How many judgment they are passing in the case?
Petitioners are agreed by the order dated 17/5/2024 passed by ADG from Special Judge Pokso Bhadrak, Special Pokso case number 63 of 2020, whereby their application, whereby his application under section 311 CRPC for recalling PW 1 and 2 has been rejected. The learned counsel also entered a clearance for opposite party number 2. Both the counsel conjointly submits that the parties have settled their disputes. The opposite party number 2 has also opposite party number 2, who is PW1 in the PW1, who was examined as a PW1, had filed an affidavit before the court dated 30/24. And even the victim has also filed an affidavit that they have no objection if the application moved by the present petitioner under section 311 CRPC is allowed, and we are ready and willing to depose before the court once they are summoned. They are summoned. Regarding that to the statement made by the counsel parties and the affidavit filed by both the witnesses before this court, I am up for the consent review that the petitioner shall be granted a fresh opportunity to move application under section 311 CRPC before the trial judge. If such application is moved, same shall be considered on its merit without being influenced by the order dated 17/5/2024 passed by ADG from Special Support Orders. With this,
One more prayer, my lord. Petition is custody, my lord.
I can't do that.
That may be considered.
What are you talking? In 311 application, you want bail? What is this? I am giving this much interest, realizing that at least things will be settled up. Yes. You move press application saying all these things.
Yes, ma'am.
The witnesses will be recalled and they will give statement in your favor. You are out. That's the best way. Yes.
73.
The last occasion, your lordship directed the counsel to take instruction whether the petitioner was a juvenile.
Yes, sir. Instruction has been. The date of birth of victim is 22/6/91.
And the date of occurrence was 24/12/2018, 17 years.
Yes.
Yes, sir.
File an affidavit.
Yes, sir.
Because I have to, if you are saying that, to where from you got that?
Date of occurrence.
Okay, place this on by way of affidavit. I'll put it on 23rd. Let him please. I'll allow it on the basis of your affidavit. Yes.
Interim order to continue.
Interim order to continue. Yes.
23rd. 77.
Pardon, my lord. Item number 74.
I don't know what happened to it. Urgent, yes.
The advocate for the husband is present in this.
I don't know. Your friend has mentioned in the morning. I don't know.
I am for the opposite party.
I don't know what to do. He said that he is undertaking that he will inform you. Rather, he said that I have already informed. What can I do? I have to believe your friends.
They have taken
I can't help it.
They have taken an interim order by false submission. That's
Then you
why
tell your friend if they are coming in the morning hour, they mention it, saying that I have already informed the
in
other
this
side.
process,
What
the
to do?
wife is getting repeatedly.
I can't help it. Otherwise, bring him. Call him and right now I'll
Warrant
make it.
advocate is present in this court.
Who has mentioned?
No, my lord, I am not
She is in power in the
Who has mentioned that?
on behalf of Mrs. Jenna.
she is also in the power.
Then
She is also in the power.
She has
She is also conducting lawyer in the.
are you appearing in this matter for petitioner?
As Mr. Jenna's son's reception is going on. Therefore, she on the part of Manning is her.
What can I do? You tell me.
Vacation do it.
1,56,000.
I don't want to get into all this thing. Somebody mentioned
Yes, ma'am.
and
She knows the case.
this is understanding in the bar. I don't understand. How you doing? Next. Don't waste time.
77.
May I please, your lord?
77.
My lord, this is an application under 528 of BNSS to unseal of residential house. Last occasion, my lord has heard the matter and state is instructed to the up-to-date CD and demarcation.
Yes.
Yes, sir.
Got it.
Instruction is on the screen.
What is the instruction? Yes, have you seen this?
Yes.
Instruction.
Yes, sir.
Have you seen the instruction?
No.
Give him. Please sit. Immediately after vacation. Yes. Seat and address. Yes. Next.
Next.
78.
Obliged.
Your value, I have challenged the order dated 28/10/24, wherein the learned magistrate has rejected the prayer for forfeiture and CRPC for release of my license gone of the petitioner. Petitioner is a
Yes, have you
businessman.
got the instruction here?
Yes.
What do you say?
And during the course of hearing in that case, so it is not required for further investigation. So further, so many judgment is there, my lord, Honorable High Court and as well as Supreme Court. So property should be released in favor of the petitioner. In the interim release, that is not interim release. And then when he will produce.
No more required for investigation.
Yes,
sir. Can be released.
Release with an undertaking, whatever.
Yes.
Yes. As per the condition.
In the persons to the order dated 20th November 2024, the IAC Malgodown. Yes, has submitted the report that is 18/12/2024 with the inside under. Read under. Like the petitioner is seeking in this petition is challenging the order dated 28/10/2024 passed by Leonard James Free Cutter in criminal NC number 51 of 2024, whereby his application under section 457 CRPC has been rejected. Rejected. The petitioner, you are not an accused? You are not accused.
I'm an accused. I'm granted bail.
Yes.
By serving that 41 CRPC.
Petitioner is one of the accused in the Malgodown PS case number so and so and so, or offense, so and so. During the investigation, the license pistol will stop to be released has been seized. In after investigation, charge it is already filed in this case and presented. This court issued notice to the state council and directed to the second seeking second pursuant to the order dated 20th/11/2024. The I report regarding head to the aforementioned, the impugn order is set aside. The petitioner is directed to move a press application before the trial court for under section 457 if such application is moved, the same can be considered in the right of the instruction furnished by the IAP, which is form part of the record and which and release the pistol on pistol and the condition of okay. Yes, allowed. Next.
81.
Pistol and other material. Diploma.
Yes.
Lord, I am on behalf of Mr. Sarthak Naik praying for an adjournment.
But actually, on last day also they have come up with the same plea. My money is there, entangled with them without any just cause. Money may be released, 15 lakhs, my lord, on the last day your lordship had. Last day also they came and they were asking for the adjournment. It was your lordship who intervened.
Yes.
They have all meetings are come.
Sarthak Naik. Mr. Sarthak Naik.
What do you want?
Adjournment, my lord.
Last time also you have taken adjournment, he is opposing. Last time also you have taken up the release of the cash. He will furnish security, property security, bank guarantee. What do you want?
Lord, except onerous liability, whatever lordship, he has been only lordship kindly sees their pleading. Without any just cause, they have taken my money. It's my mother's treatment money, my lord. My lord, whatever without this person is a respectable person of the society, my lord, he has been entangled, he's a professional person.
Yes.
My lord, lordship kindly gives such
You seek instruction, he will furnish security. Let him furnish security. I'll release cash. Friday.
and I'm not getting any, my opportunity is also lost, my lord, that 15 lakhs.
All right, Friday.
Lordship, please list it after 11th.
No. Fridays. You can't keep on asking for adjournment. Without his money and you have to, he will furnish the security, the property security, whatever security you want. I'll release that 15 lakh rupees. Huh? Sorry. Yes. You seek instruction. What kind of security will be suffice for the purpose of release? You simply tell I'll that security I will they will furnish and I'll release. Okay. Whatever security.
May I be permitted to submit a bit, my lord? My lord,
Sorry.
may I submit a little bit?
Yes.
My lord, it is there. I'm sorry if I'm permitted to say, in the last time also when I had another matter of the wife of that person to get the release of the ornaments.
I'm keeping it Friday. Let him get the instruction.
Yes, my lord.
Regarding the security part, you get the instruction. Friday. Yes. Yes.
49.
Two matters. Another matter.
49 and 15.
How is the matter? There is another matter, 330.
I am also taking that matter, 330. But let it be taken up first.
Then another 10, 15 minutes. Let us see. I'll just. This matter is come.
Because I am told that our suggestion has not appealed to my learned friend client on the other side. But we are here to assist. Let me place the matter.
Yes.
I'm here.
Lord, just to point out,
Yes.
Lord, we had given them an option about this offer regarding arbitration. Now, if that doesn't appeal to my learned friends, my learned seniors.
We have not. Nobody has given any option to us. Arbitration, what we said.
Arbitration, sir, we've got.
No, I have not said arbitration. I said that if possibly, if you can work it out, work it out. If you can't work it out, then it has to be heard. That's all.
I bow down, which is why I'm.
Can I just tell your lordship in a minute, Lord, why we made that proposal, just to clarify? The issue is really this.
May I say this very clearly? And I want, which is why I said it, and in the morning.
Let me just finish.
Because-
Let me have a minute. I was told on phone that are you interested for arbitration? I said no.
No, I have.
Correct.
I was just
Exactly.
exploring a possibility.
Exactly.
Can be done. It can be done because I got an idea that it's entirely a commercial dispute.
No, serious allegation of forgery. That is the important. Serious allegation of forgery.
Forgery.
Criminal case is pending, where anticipate bail has been granted with certain conditions.
That's right.
Then there is no question of
Yes.
mediation.
Yes.
Let us go.
No arbitration.
It's simple as that.
Please have the file of page 40, of item 49.
The 49. Huh?
Please.
Then this is the lead matter. I'll take it.
Please.
Okay.
And one more matter was listed, my lord, was mentioned. Another matter is also listed. But my matter, which was to be listed today, was not shown on the list to my friend, Mr. Mishra, and was here in the.
Allegation against him in the FIRs. Out of the blue, they.
I'll have to see. I'll have to go one by one.
That's right.
Let us understand what.
My matter has not come up. That is why, my lords, it was filed day before yesterday.
Your
It
lordships
has
will
not
look-
come up. So your lordships may just bear in mind that my matter is also pending before this honorable court. Because there is no allegation against me. They have.
How many accused persons are there in this?
There are
20.
12.
Out of that, my lord, one person who can anticipate the bail, your lordship said, submit the passport.
No, that's a different matter.
Different
I
matter.
have to tell something.
No, we are, no, that's not a problem. Why are you avoiding?
Conditional order has been
Very-
passed.
Not, now, lordship may proceed on merit.
I'm not hearing the bail.
We are not-
I just concentrate because investigation is still going on.
Yes.
I'm wondering why should I venture into all these things?
No, no,
That's the only worry.
May I just-
May I only request one thing? Since I am the petitioner in item 49, which happens to be the first matter on your lordship's book.
Let us proceed.
Please just
Yes,
start.
right.
And within that framework of quashing, let us assess whether we have more than a prima facie case or not. Otherwise, your lordship will relegate us to wherever we have to go. But please have, look, there are.
Let us understand.
Straight away.
Let us understand.
Look, what I have done for facility, I have made a note for your lordship's consideration, which has all the relevant pages as well. Let me hand that over.
Mr. Agarwal, just give me a moment.
Yes, Mr. Luthra.
Mr. Agarwal is in court, let him be heard, Lord. Thereafter, my matter, which was to be placed today and which we had mentioned in the morning, may be heard after that. I'm here, but let Mr. Agarwal, since he has he has the benefit of being physically before your lordship, let him have the first right to be heard, Lord. That's all I'm saying. I'll go on after him.
Yes.
Lordship, we just have this note for the purpose. Please come, Lords, to para 2, which is the brief background.
Yes.
Where the complainant and others were promoters and shareholders in a company called Nestaway. Various funds and institutions such as Goldman Sachs, for whom Mr. Luthra appears, Tiger Schroders, who are not here before your lordships, and other funds were investors in the company, as was I, which is the petitioner.
Tiger Globe Singapore is not there.
Tiger Global Singapore is not before your lordships. Schroders Advec is not before your lordships.
They're on the way. They will join us.
They are already part of the FIR, but they haven't.
They must have been.
They haven't reached here as yet.
They would be joining.
That's right.
Yes.
Now, para 3. In 2022, shareholders were considering a sale of their shareholding in this company, Nestaway. During this process, negotiations were underway on the terms and conditions. Transaction was finally executed. Please mark this date, 28th of June 2023, through a share purchase agreement for the sale of shareholding to one Aurum Prop Tech Limited. There's now para 4, 3 allegations. They filed a short counter. These are the 3 allegations raised by them. Number 1, that the complainant claims that the investors promised him that out of the share, my share of the sale proceeds,
we will carve out and give him 11.72 crores additionally over and above the entitlement of his sale of shares. On this basis, according to him, my lords, he agreed to sell his shares, after which we have reneged on our promise and hence we have cheated him. This is allegation number one.
Yes.
Allegation number two, that his signatures on some other document has been misused and been made part of this share purchase agreement. So what he says is, share purchase agreement has 2 pages on which he signs. One he signs in individual capacity. The other he signs on behalf of the company Nestaway.
Yes.
He says that on each page, there is a footer. There are 2 lines saying this document forms part of the larger document. Look here on the page on which I signed in my individual capacity, it is written. On the page which is written for company, it is not written. So and I had resigned by that day from directorship. So, sir, my other document, some other document which was lying with you has been used from there, put in here. And that is why, according to him, this is a forgery.
471.
This is a forgery according to him.
Yes.
The third allegation is that somewhere in August of 2023, so share purchase agreement done in June, everything over. In August of 2023, one person traveled to Bhubaneswar and threatened him with dire consequences, and that is the allegation of 506. So these are the 3 allegations that we have to deal with. Let us go, Milord, to what has happened prior to this FIR.
First two transaction has taken place where?
Everything outside of Orissa, Bangalore is the stated position or venue of all dispute resolution. In fact, and that's what I'll show to your lordships, 4 attempts made prior to this FIR. So it is not a situation where
then 506 is invoked
for
in
Orissa.
that it has threatened from here. That's what. Okay.
And your lordships are aware 506 is a non-cognizable offense. Under normal circumstances would not have been capable of giving jurisdiction to a police officer to register an FIR. And that is why really the first 2 allegations are the allegations that we have to contend with. But be that as it may, for 506, allegation is for one person. So let us now go to this FIR is registered, my lords, in the year 2024.
Yes.
In September, 23rd September 24. 4 attempts made by him prior to this on these allegations. What are those 4 attempts? Please have now the section attempt 1. After the execution of the SPA on 28th June 23, certain disputes arose and the complainant made a formal complaint on 28th of August to SEBI, agitating his grievances regarding the breach of promise to pay the aforestated 11.72 crores, saying that these people told me, they did not give me. SEBI should now investigate this.
Yes.
2 points of note there. First bullet point, no allegation regarding any misuse of document or forgery was made, and the complainant admitted that yes, I have executed this document. So that is point number 1. But second point, SEBI closed this complaint saying that this is a dispute which pertains to a private agreement with the companies and their intermediaries. I as SEBI have nothing to do with it. So I am not going to enter into this domain. So this is his attempt number 1. Attempt number 2. He makes a complaint to the Ministry of Corporate Affairs on 31st of August 2023, requesting for an investigation in respect of corporate fraud under 447 of the Companies Act. I am not aware of the exact nature of the complaint. I only know that such a complaint was made. Now please turn to attempt number 3 over the page and we'll deal with what happens to attempt 2 and 3.
Yes.
5.3 below.
Yes.
Complainant then on 22nd November 2023 files a petition before the National Company Law Tribunal
Yes.
in Bangalore. So he invokes the jurisdiction in Bangalore, seeking various reliefs against the company Nestaway, against the subsequent purchaser and the various investors and our representatives.
Regarding this 11.72.
Because the reliefs claimed are with reference to the company, but the allegations are my 11.72 has not been given to me.
Was it a section 7 petition?
No. 241, operation mismanagement. So he could not have made a money claim in that. But the allegation made, oh, look, I have been oppressed. The company is being mismanaged. Why? Because 11.72 has gone. 11.72 is not being given.
Yes.
In this,
No allegation.
And I've noted this, because petition proceeded on the core grievance of the complainant regarding non-payment of 11.72 crores. I put the para numbers. I can take your lordships if so required.
Yes.
Again, no allegation of forgery, no allegation of misuse of any document, no allegation of any threat in Orissa, saying that so somebody came to Bhubaneswar and he gave me a threat. This is filed in November of 23. Allegation is so-called of August of 23. No such allegation made. Next point. And this is the critical part. He then on 3rd of June enters into a settlement agreement with some of the respondents. He gets 4.2 crores out of that settlement. He pays back 4 lakhs, saying that yes, this money was not supposed to come to me. I have now given. And with the settlement agreement, he withdraws the MCA complaint and the NCLT petition.
Okay.
Unconditionally for everybody. It's not as if he said, oh, sir, there were 15 respondents. These 3 respondents have settled with me. They have remedied the problems. But the other 12, I will still proceed again. No. He gets the settlement done. The NCLT in a judicial capacity passes an order recording that settlement. And then on that basis, the NCLT petition goes away. He also withdraws that MCA complaint saying fraud. Everything is over. So attempt 1 over, SEBI says no. Attempt 2, he withdraws. Attempt 3, he withdraws. He gets a settlement done and he files and he gets a money out of that settlement. Now please look at attempt 4. Complainant then issues a legal notice on 5th of October 23 to persons associated with the investors, claiming that he had participated in the share transfer agreement in good faith, but subsequently there is, and these are the words used by him in the legal notice, that there is a breach of contract. Yes. On this basis, he makes a money claim for his share of the additional carve-out payments. Because this legal notice, your lordships will find, is part of item 50. Yes. That is the individual to whom the legal notice was issued. So this is a legal notice which is on your lordship's record.
Yes.
No action, no recovery proceeding, nothing done, even on the strength of this legal notice. So from June of 23 down till June of 24, 4 attempts made, none of those either taken to fruition or nothing done. In none of them forgery raised an issue, in none of them allegations of any threat. But now we come to the FIR,
yes,
which is done in 23rd of September. Please have the FIR straight away for a moment, page 47, annexure 1.
23rd September 24.
I am most obliged. Throughout, he relies on the same agreement. He gets monies because of that agreement.
Yes.
And now for the first time, the allegations I had culled out 1, 2, and 3, which is in the previous page. Yes. Number 1, you did not pay me 11.72. I said yes to this transaction because you promised me 11.72.
Yes.
Number 2, misuse of document. Please come, Lord, straight away. Let me take your lordships to 3 or 4 pages and demonstrate that this is a situation which will shock your lordship's conscience as to how things are being done. Please come, my lords, to my petition and let me show the document which he relies upon, which is in his favor, which says, yes, 11.72 must be given to you.
Show me the NCLT.
NCLT order, my lord, straight away. Page 224, annexure 6.
Yes, I am there.
Is the order.
Yes.
Heard the learned counsel, your lordships will find respondents 10, 13, R7, 15, 17. These are all investors.
Yes.
His settlement is with only the company and the subsequent purchaser. Heard learned counsel for petitioner and respondents. Learned counsel for petitioner has filed a memo for withdrawal by diary number so-and-so, stating that the parties have entered into a settlement and executed a settlement agreement on 3rd June 24. Therefore, he requested to permit him to withdraw the present petition with liberty. And please see, what is the liberty? Liberty to the petitioner to restore the said petition in case of breach of any terms of the settlement agreement. In view of the above, CP number so-and-so is disposed of as withdrawn. All pending CA stand closed. This is as of June.
Come to 216.
216, Mullah?
Yes.
Straight away. 216 is the settlement agreement.
Yes.
This is the settlement agreement.
This is the informant in this present.
A is the informant.
Yes.
B is the company, the target company, Nestaway.
For whom Luthra appears.
No.
Shareholders.
The shareholder, all of us were shareholders in Nestaway. So Nestaway is the target. He is the founder shareholder.
The directors of Nestle. We are appearing.
He is the founder shareholder. Everybody else were shareholders. My learned friend also appears for one of the other founder shareholders. And C is the subsequent purchaser. So the person who actually made the payment, CORAM.
Okay.
Please see under whereas in the recitals, para A. In the year 2023, various differences and disagreements arose between Amar, that is the complainant on one side, and CORAM and Nestaway on the other side. Pursuant thereto and in connection with the aforementioned differences and disagreements, complainant filed a company petition under 241 to 245 of the Companies Act, numbered at so and so before NCLT Bangalore, along with company application. Para B, a letter to the Ministry of Corporate Affairs dated 31st August requesting for an investigation to be undertaken under 210 or other applicable provisions and imposing punishment under 447. Both these, now please see what happens in para C. Pursuant to deliberations and discussions between the parties have mutually and amicably agreed to settle all inter-se disputes arising under the share purchase
What is the
agreement.
date of this?
3rd of June 2024 is the settlement agreement. 6th of June 2024 is the NCLT withdrawal. His best case for some of us is,
yes,
look here, the settlement is not with you, but the withdrawal is for everybody. But plus, let me not stand on this technicality. Let me show something which is more shocking. Because in essence, his case is, sir, they promised me 11.72.
So you come to D.
And
17.
I'm most obliged. I bow down. On the closing date,
D.
I am most obliged. There is nothing in this case.
Yes.
May I, would your lordship, because your lordships have borne with me for.
I understood it.
Two more pages on the 11.72, and then because I'll have to deal with the forgery as well. Please come straight away to the document that he places great reliance on. Page 65.
65.
Please one.
Yeah.
He says, this is an email of November 2022. So while we are doing that entire negotiation, he wanted some more money for himself. That was under consideration.
Yes.
8th November 22, your lordships will find the date in the second line. Please see point number 1.
Yes.
Based on the term sheet from Aurum Ventures valuing the company at so and so and following Amar's request for rewarding him and his team's efforts in the last 24 to 30 months, we had agreed to a carve out from the proceeds of the transaction. As a result of the recent conversations, we have arrived at a carve out of an amount of 11.72 crores in addition to the pro rata payment. This is the document, Bullets, which is his entire case on 11.72. The date, Bullets, is 8th November 2022. The transaction finally, the final document is signed in June of 23. When is it that he is told that, sir, this 11.72 is not on the table? Is it 5 seconds before he's signing? The answer to that is no. It is on 8th of February. Next page.
Yes.
8th of February 2023, 4 months prior to his signing that document. This is an email your lordships will find of 8th February 23. And second line, he is a recipient of this email. Hi all, we have agreed on the following construct to move forward on the transaction with Jitu and Amar. Jitu Milad is on my left-hand side, accused. Amar has claimed himself to be the person who's been wronged on my right-hand
Jitu is
side.
the director.
Both were directors, both were founders. The complainant wanted, both of them had shares. Everybody basically was getting the money for the shares that they had. The complainant wanted, no, I will get my 4 crores for the shares that I have. I want 11.5 more. Don't pay A, B, and C who are other persons. I have done so much for this company. I am so special. Give me more money. November 2022, that we were considering. February 2023, please see this. Move forward on the transaction. Third bullet point, payout basis the cap table, meaning on the whatever is the shareholding, brackets, no carve out for any founder. Not a single penny will be paid.
Yes.
From February till June, silence, no problem. Please come, Milords, to the next page. Page 75.
Yes. Yes.
Page 75.
Who is Sudhir Seth?
Is the petitioner in item 50 and part of the company in item 49.
Yes.
Please come to page 75.
Yes.
This is an email from the complainant on 13th of June. So now from February till June, nothing relevant. Please come to June. Hello everyone. First things first, we are ready to close the deal.
But all these things had ended up in the NCLT.
Ended up in the document which did not give him 11.72. But please see, now he raises this issue.
Yes.
Saying give me 11.72 more. Second paragraph. Please turn over the page.
Some assurance. That part.
I want to understand how the investors plan to pay me the promised amount of 11.72 crores. Second para.
They want to understand. Yes.
Please turn over the page, page 76.
Yes.
Amar, we have been discussing the draft terms of SPA for some time now. You have been privy to all this. These terms are the final negotiated positions and cannot be opened out for any further payments at this point, particularly if monies have been withdrawn from dues paid in terms of tenants to the company. Attached is the last version circulated. All parties are willing to sign and move forward. Please confirm by end of day today if you are willing to sell with us, or otherwise we will assume that your final decisions remains to stay back. Nobody is forcing him to sell what he has. He's saying, I want more. We are saying, no, we will not give you more. You are now told. You are told on February. You ask again on 13th of June. You are told on 14th of June. You are told on 15th of June. What do? You sign the documents without the further thing on 28th of June. Page 78.
Yes.
Page 78. My position on this remains unchanged. While I do not agree with your position, I have noted it. Like I said before, I have no option but to participate in the sale. This is to confirm my participation. I will begin handing over documents to AZB, which is a law firm. Now, in this context, so I now want to ask myself, I'm told in November of 2022 that I will get some extra. In February, I'm told that is not happening because somebody else has a problem. So there are negotiations, multiple things happen. June, I am again told, I sign the document. Disputes arise. I do attempt 1, attempt 2, attempt 3, attempt 4. I don't file a civil case. I don't go for recovery. I don't do any arbitration. I file that NCLT. I get my 4 crores from those people and I resolve it and I sell it to everybody. Now, in this context, filing this complaint and this FIR, which is then registered, and without telling the investigating agency any of this, all of this is suppressed. NCLT is suppressed. These emails are suppressed. None of this forms a part of his complaint. Now comes the so-called criminality of that forged document. Please just have 2 pages with me. What is his case? Because I am with utmost respect saying, if a litigant of this nature can be allowed to even take the system for a ride for more than 5 minutes, it's a reflection on all of us. Please have, what is his case? Please come to page 154 first.
154. Oh, yes.
Page 154. That share purchase agreement of June, he signed on 2 pages.
This is the document.
This is the document. I'm taking your lordships to those 2 pages which are relevant to his case. Page 154 is a signature in his individual capacity. Your lordships will find that. I'm so sorry.
Yes. Yes, I'm there.
All the signature page where 38 people were signing.
Yes.
So 38 originals were made. In witness whereof parties have executed, he signs it. Please see the foot of the page. There is this thing in the small print. This signature page forms part of the share purchase agreement between Aurum, Nestaway and its shareholder. Your lordship finds that?
Yes.
This, he says, no problem. I gave this document for this document. Why? Because it says this. Look here, the other 30 people who have signed this document, theirs also says this. Please have the page before this, page 153.
153, yes.
He says this is a document which is for and on behalf of Nestaway. It is signed by me. But look here, sir, there is no foot at the foot. There is no short thing saying this document forms part of that agreement. So evidently, because I had resigned by this time, somebody has taken this page from somewhere else and put it into this document. So let me first imagine that that is correct. If that is correct, he files this document in the NCLT. He files it. He realized it. I have filed the document that was filed by him.
Part of the petition.
As part of his petition.
This document was formed part of the
NCLT petition filed by him, on the basis of which he claimed oppression and mismanagement. On the basis of which he has received 4.2 crores. Otherwise, there is no other document under which he is entitled to 4.2 crores. This is the document. But I will say this.
I understand.
And I will say this. He has given this document under email. I have material. I have it here. I can demonstrate it here in 5 seconds. That he has given one which has the line at the bottom. Then he's asked, give us the physical. He takes printouts of 38 pages and sends it. Each one of them is here. Let me show it. Because this is the kind of falsity, absolute falsity.
Yes. Which page is that?
Let's please first
41.
come. Please first come to page 1. Page 1 is an email of 6th of June.
6 June, yes.
6 June, he is writing, complainant is writing, hi Nandita and Karishma, please find attached the signed company page. Please submit this to only on closure. This is the company page. Please turn over the page. For the company, with his signature, and your lordships will find at the end, there is that footnote.
Yes.
Your lordships have seen this? Now please come to page 4.
Yes.
There is an email at the foot of the page, 15th June.
Yes.
This is from Karishma Dugar. I'm so sorry. I'm so sorry. Page 5. Page 5 at the top.
Yes.
Karishma Dugar. She says, hi Amar, while we wait for the share certificate and share transfer forms, we have other pending items. Please see item number 9. Physical copy of the company's signature page to the SPA. Physical vetting signed copy is awaited. Your lordships noted this? Now please come. I'll just request my learned friends to allow me 2 minutes and then the floor can be theirs. Please come to page 4.
Yes.
17 June 23. He writes back to Karishma saying, I have dispatched an office boy with the signed copies of signature pages to your office. I have sent you all resignation letters, release letters, so and so. Please come to page 3.
Yes.
Karishma writes back saying, hi Amar, confirming receipt of attached 38 signed SPA signature pages at our office. Please come to any of the pages from page 8 onwards.
There is no.
I am most obliged. Each of them are physically signed by him.
It's not.
This is the falsity.
Yes. Yes. Who is appearing for complaint? Let us understand. You are appearing, Mr. Roth.
My lord.
All the question is, now my learned friends has filed certain documents. Is it possible to look to this document and give reply without consulting? But we keep it tomorrow, we can verify this.
I'm here to argue now.
There is an FIR. We have to go by the FIR.
No, I am only wondering whether it is an arm twisting method of filing an FIR. Right? Everything happens somewhere else. You invoke 506 and lodge an FIR. And apparently all this thing, whatever he says is correct. It's correct. Provided is correct. Correctness has to be checked by a right person. I am not on that. Right person is the investigating agency. He will look into it. But it apparently looks that your repeated attempt you have failed and you have not made allegation anywhere. First time you come and make an allegation of it. Yes.
Or my learned senior can put the mic towards himself. I'll have the privilege of listening to him, hearing.
You want get out the voice?
No, he can see my face, know what I'm saying.
But I am happy to see my learned senior and my learned elder brother, not, but I need to hear it because
Elder brother is a more appropriate word. That is what you have been using for 15 years. Senior ka
That
hai.
meant that
I
part
will
we
continue to use it sir, for the rest of my life.
So, my lord, here is a entrepreneur
Yes.
who formed this company. And where all these people came, the company was doing extremely well. Like many of these startups, it did miserably bad in the COVID. Let me tell you broadly what is this case all about. And then investors were there. At the COVID time, all of them left. They all resigned from directorships, subject to correction by my learned friends. And after the COVID went away, this young man started reviving. And then these big companies, they said, we want to sell this company. What they told me was, or what was arranged was, that we, for 5%, by that time my share has been diluted to 5%. You will get 4.5 CR for shares. And for all the hard work you have done for so many years, you will be given
11.7 crores.
Now, the NCLT was not for realization of either that 4.75 or was it for that 11.7. The Lordship has seen the prayer in the NCLT, it was nothing of that kind. And NCLT was primarily between
NCLT because of mismanagement to you,
Yeah,
but you
absolutely.
settle for the whatever terms.
So therefore,
Yes.
the company which purchased that Aurum, that said, look,
I'll give 4 crores.
So far as
You be happy with that. That's what they said. You got happy. Yes.
It said that for your 5% share, I will give your share price. Right? You have no problem with me. I never told you I'll give you 11.75.
Yes.
Because when this Aurum sale questions happened, I was told by the clients of my learned friends, I was initially saying no. I have arranged 50 crores from somewhere, let us run this company. They told me that because you started this company, you will be given 11.75. You agree, and we will sell that company. So there are two different branches. One is the share price, that 4.75, where the NCLT settlement happened primarily between Aurum, the company which purchased, and they were facilitators in sale. So that was my share money.
Yes.
Now that 11.75 is what was promised to me by email to begin with. When I said that, look, let us not
So
sell
then
this.
your grievance is revolving around.
That is one.
7.75 crores
This
now.
is, no, but this is one part.
4 crores you have taken.
Yes,
In any case.
But 4 crores was my share money.
You have taken that.
I have
Your
taken-
entire claim is 11.75.
Which was probably
You have
one.
40 for 4.
Which is one.
Yes.
Now what they do, minutes. Lot is said about this document being filed, this document being filed there. Now I resigned from the membership. I resigned from the director of the company. And my lords, that was also
1960.
approved. So that was not, I resigned from the, I was made to resign from the company.
662.
Which page is that?
662.
61?
662.
Yeah, yeah. Copy दिया ना?
Copy there.
Quote दिया. Not I resigned from the company. I resigned from the company on June 19, 2023.
Yes.
That your lordships will get at page 10.
10.
Right, my lords?
Yes.
Let us see what is this. Taking off resignation of Amarendra Sahu from the office of the director of the company. Your lordships have it?
Yes.
Resolved that the resignation letter submitted by Amarendra Sahu, office of the director of the company, is hereby taken out with immediate effect and signed by whom? By Jitendra Jagdev.
Yes.
No problem. Kindly see the next page, my lords.
Yes.
ROC accepts it. Kindly see, my lord, right hand side, second box. Next way technology. Your lordships have it?
Yes.
Come to the bottom of the page, Amarendra Sahu.
Yes.
Kindly go to the next page, Millets. 19/6/2023, bottom of the page, Millets.
Yes.
On the same day. So everything is done now to fast forward because I have to go. Now,
Go with your own claim.
I'll come to that. I'll come to that. Now, Millard, page 17 is June 28, 2023.
Yes.
That is the share purchase agreement. Right, Millard?
Yes.
When have I resigned? I have resigned, your lordship saw 19 June. Page 10. And this is happening definitely after 19 June.
Yes.
So 28 June, Millets. They wanted first me to resign. And when I said, where is my money? He said, forget the share purchase agreement. That is between us. I'll show all that.
Yes.
So now if your lordship sees page 19, this is the registered document. And page 20, this share purchase agreement is made on 28 June 2023.
Yes.
So I have resigned by that time. Now let us see. Kindly come to page 42.
42.
Yes.
Yes.
Kindly look at the bottom of the page.
There is no foot.
No, not only that.
There is that's the offense you see. This foot.
Now your lordship may see 42.
Yes, I have seen that.
Correct?
43 rather.
Yes.
43.
Now 43. Right, Milord?
And you say except 43 in every page it is there.
Kindly see. Milord, there is something more interesting than that. Kindly see 43.
Yes.
Signed on behalf of Nestway Technologies Private Limited. I have already gone on 19. You have accepted my resignation. So how could you do this? You know, these are all big.
What about the email?
I'll come there. I'll show that. So therefore, very well knowing that on June that I have already resigned from the company.
So you say by the time I had resigned,
not even a director.
This page is introduced subsequently. That's what you're saying.
Look at the signature at page 43 and look at the signature at page 44. This is by Amarendra Sahu. Right, my lord?
Yes.
Shareholder. And the other one is what? Amarendra Sahu. Why should he sign? Why should he sign? Is he a director?
Which one?
Page 43 and 44, your lordships will find.
Yes, 44. Yes, 44. Yes.
So Amarendra Sahu at
In the capacity of
no problem. So you could not complete this documentation without my false signature here. Because the director had to sign it. The person who was buying the company, he wanted the director to sign, the other director did not sign. And what you did, knowing very well that this person, Amarendra, is no more there as a director of the company from June 19, 2023, you now forge his signature to complete this transaction. I don't have to argue anything more. Let the police investigate and tell your lordships. All these good stories are
then
fine.
how will you explain the email trail?
I will show the email trail.
Email trail.
I will show the email
It was
trail now.
repeatedly sent to you. It was
I will show
your
you,
knowledge.
I will show you where this 11.75 crore from.
Keep that aside. Only let us understand
So I have
whether
shown
this
your-
is forgery.
I have shown
then
your
trail
lordship-
mail. You
I
have
have
to see.
shown your lordship that this document is forged.
From our side.
Let us accept one fact. Let us accept two facts because here we are not doing a trial. My lord, it is not in dispute that with effect from 19th June 2023, I ceased to be a director of the company.
Yes.
There is no difficulty there. We don't need rocket science for there.
Right.
And now kindly come to page 43.
Yes.
This is the share purchase agreement. This itself is fraud. So how can a person who is not a director represent the company? And if your lordship looks at these two signatures, that also tells a lot of story. My eyes are not too good because I'm putting on age. But those doesn't seem to be the signature of the same man. Forget all that. We will not go in there. Amarendra Sahu, having resigned from the director, could not have signed this as a director representing Nestway.
And in the personal capacity. That's what it is.
I'm a shareholder.
So which signature is correct then?
Not according to me. I could not
43 or 44?
I could not have signed as a foreign on behalf of Nestway. Who am I? I'm only a shareholder. I'm not even a director. So this is the fraud. I may have filed it in 20 places. Does it cure the fact that my resignation as a director, if not disputed with effect from June 19,
what has prejudiced you?
Now what has prejudiced me is, so A, this document is forged. That's
Let
my
it be.
submission.
What is the
Now this document being forged, who am I? Let's understand that. I am the founder of this company.
you have crystallized your claim to be 11.75.
No, I have
No, no,
Not
no
beyond
question of any
I have
claim.
crystallized. My learned friends, clients have, I'll show that in a minute.
But you have agreed for that.
So let me, yeah, where got 11.75?
Therefore, I'm saying.
Where is
Therefore, I'm saying your claim at best would be
But my
7.75.
My submission is 234.
Yes.
My lords, I have shown your lordships that as on the date on which this share purchase agreement was executed, I was not a director. My lord, we are clear on that.
Yes.
Now, therefore, assume that page 43 was not there. And there was nobody representing Nestway Technologies. Would this transaction would have happened?
That itself is a fraud.
Yes,
No, that itself is
So
a
either
forgery.
you are or I am.
No, that's right.
Yes. Yes.
That's right.
Right.
But it would have
So
happened.
therefore, my lords, whether the signature is right, whether the signature is wrong, whether he could have signed, not signed, these are matter of investigation. This is point number one.
Who else has signed for Nestway? Except
Nobody.
I'm
Nobody.
grateful.
Nobody.
I'm
Nobody.
No one is signing.
No one.
No one is signing. Why did the other director not sign? I asked myself the question.
This is the.
Why was except Amarendra Sahu somebody else not made to sign? Because nobody was willing to sign. Because this whole transaction was actually not to the interest of Nestway.
And who represented Nestway in that?
Yes.
He did.
Nestway. Remaining director.
In the document.
You are not party to this.
No, I'm party to this agreement. In fact,
Why did he not sign? He was a director.
why he did not sign is a hypothetical question.
May I just.
Out of thin air.
So no, that
But
thin
you
air-
agree with this?
That thin air will be.
I don't have a copy of it because he.
May I assist?
See, in any case, it needs to be gone into it.
May I assist?
What I will do is, what are the interim order you?
I am. This
Let us have some interim arrangement and let me
Interim order will have our objection. Your lordship will kindly hear. One judgment is there. I'll cite. Then your lordship is free to pass it.
On this, brother.
Lordship will see Justice MR says judgment only. Then your lordship consider the interim order part. Then your lordship will. I have no objection to that. Kindly see this.
Show the judgment which
Kindly see this judgment. There. MR says.
But the main stakeholder is giving something.
Yes,
What you want to say?
Sir, kindly turn to page 15.
Honorable Apex Court has stated that.
Yes, read it.
Apart from that, my lord, for the investigation, my lord, since there is a allegation of forgery of signature, and that is from the face value, it's clear that there is a forgery, my lord, and signature has been forged. So the investigation is required. I'm
required, but see, the FIR was registered when?
Your lordships may kindly.
23rd September.
What have you?
Because they are, I've given this.
Can I intervene for a moment, Lord? Just one moment, God.
Sir, kindly.
Para 3-4
investigation stage.
Yes.
Show me that.
Para 3 that the complaint revealed that informant's allegations are essentially threefold. Forgery and fraudulent use of his signature as the director of Nestway in the share purchase agreement dated 28/6/2023. The accused persons 1 to 9 being the erstwhile investors, shareholders, accused investors of Nestway Technology Private Limited had deceitfully promised to pay out a sum of rupees 11,72 crores to the informant and had conspired to induce him to sell his shareholding and the company to a listed company named so and so, so and so. Then your lordship 4, that on curiously looks at the affair, it is luminous and you see that the accused persons dishonestly induced the informant to pay him rupees 11.72 crores if informant signs the sale documents. Being persuaded by such dishonest inducement, the informant, believing their promise, which was given at the very inception of the transaction, completed the sale document, but subsequently the accused persons did not pay amount of rupees so and so, reflects the dishonest intention of the accused persons. Otherwise, they would not have intentionally deceived the informant. Had the informant not been so induced by the accused persons, he would not have executed the sale document. due to dishonest inducement and consequential execution of sale documents, the informant ultimately suffered and under section so and so is made out, my lord. Then your lordship may kindly see para 8.
Para 8.
My lord. 7 and 8.
Yes.
That during investigation, the complainant has examined some documents pertaining to the informant next to a technologies private limited, CORAM Profits Limited, as well as emails WhatsApp so and so from the complainant, which includes the photocopy of share purchase agreement between so and so, registration so and so of Amarendra Sahu, as well as resolution passed in the meeting of so and so technology private limited held on 19/6/2023.
Yes.
Regarding registration of so and so, my lord.
Yes.
So, my lord and senior appearing for the informant who is stated that their signature is forged, my lord, unless that is given to the my lord for experts for investigation. So, ascertain to that signature, because in the black eye, in the my lord, naked eye, my lord, it is seen that that has been forged, my lord. So, for that reason, my lord, prima facie in FIR, my lord, the offences are made out. So, my humble submission to the lordship is, once the prima facie case is made out, at this stage, whatever the documents they are supplying before the honorable court, and the honorable court cannot go through the details of the case because the investigating agency is investigating the matter. For that is my humble submission, lordship.
You say cannot go through. I have already gone through. What will you
One second.
Now I am. Let us find out.
May I take a minute? Kindly see this order. Kindly see this. May I take a minute, Miller? I am appearing the.
Let it.
1 second.
Yes.
Other second.
Yes.
This case, what fell from your lordship?
Yes.
We had a division bench of Chief Justice Sujit Barban. So one document was handed over. Then Mr. Jaitley was appearing from the other side. He said, no, you can't see this document. He returned it. Hearing went on. After 10 minutes, he said, Mr. Jaitley, what will I do? I have seen it. It has gone into
I have the same trouble. May I just take a 5 minutes? Just 5 minutes. 5 minutes, may I appear? 1 second. So look, so the interim order will also come.
One accused had come.
It's a bit bad.
Let us strike a balance.
No, may I just
see that?
Let's take it. Let's take a minute, my lord. The entire issue before your lordship is interlinked. What is the main lordship may say? So, lordship, the entire issue before your lordships, have I given the assurance to them and 11 crores, and did I that assurance continue? What they would do, my lord, it's a very serious matter in the extent, my lord. All 11, all international, yet they will hesitate to come to India if this criminal case is made Damocles sword against them.
them not.
They'll hesitate. They're commercial.
All ODIs
Please, the ODIs cannot take a, nothing has happened in Odisha. Nothing has happened in Odisha. It's all just, I just tell you also, what they do not conveniently bring to your the notice of the affair, that's the malafide. Is that it was not agreed to pay him payout. If that is not there, what is the basis of the claim?
But that will also be not deciding here.
That's not decide. You will, if it is a malafide affair.
One second. Para 9 of this order. Kindly see. Para 9 of this.
Plus, I must point out 2 sentences in rejoinder because a lot was said.
Kindly see para 9 of
But this
that
is anticipating an order of somebody else.
Lord, as an interim measure, petitioner shall not be arrested in connection with the same case till next date, but subject to condition that he shall cooperate with the investigation and appear before the IO. As and when his presence is required for the purpose of investigation, he shall surrender his passport before the court.
Part, your lordship is true. Passport, your lordship is true. But that is the issue of passport. They are wasting, Lord. They are wasting. They are wasting. They are interesting.
This is an order.
Yes.
I am exercising 482.
Yes.
I have to balance. What my suggestion is, I will hear further tomorrow.
Yes.
Day after.
You
See, the entire dispute is regarding that 11 point.
Yes.
You deposit that money with the IO and and the 4 crores which he has taken, You detect that.
No, please, allow me to, please allow me, your lordships are putting something to me.
Yes.
Your lordships are putting something to me. I should be able to respond, Millet, to that your lordship.
See,
I'm so sorry, Millet.
that will not be disbursed to him.
No, I'm so sorry. This is something.
Yes.
Absolutely no allegation against.
So let that case come.
I can't go individual cases.
Please allow me to.
Investigation is going on.
Please allow me to respond to. Please allow me to respond to your lordship's suggestion, which your lordships is seeing as one of the balancing factors. If your lordships have found that prima facie there is any document or assertion by which I owed him any money, let alone 11.72, that position of deposit, even in those circumstances, would be onerous. That's point number one. But number two, your lordships have found that the document finally done is for 4 crores. He has got that 4 crores. And I'm sorry. And today, through the investigative process, in my petition, I cannot agree to those terms. That much is clear. If your lordships feel that that is an order that has to be passed, no, that's a different story. But I am beseeching your lordships to consider this. In a case of cheating, where a person has signed an agreement, has acted on that agreement, your lordships have been told, look here, one of the signatures is wrong. I'm sorry. The entire case put by them is both my signatures are correct.
The problem is, can I preclude the investigating officer to go into?
I
preempt everything.
I have a suggestion.
That's
the whole difficulty. I have a suggestion.
We are agreeable.
And if it is higher side, you can very well check.
I have a suggestion.
A little bit and pay. And
I'm sorry. The suggestion is this. The suggestion of lordships is this. Your lordships may pass an order saying that let them investigate, including the material that we have provided.
Yes, that I'll
no coercive steps in the meantime. And we will cooperate in providing them the information. But the fact of the matter of depositing any money when a person has not no, I'm sorry. When he has not even filed a single case, after he has filed a legal notice, he has withdrawn it. Why should I deposit a single penny? The question.
Then perhaps this is a petition under 438 in disguise.
No, I'm so sorry. Actually, my prayer is for stay of investigation. And under Niharika, please have the judgment in Niharika that has been handed over.
Niharika.
Straight away. 2 judgments that your lordship. I am seeking stay.
Niharika.
I am seeking stay of investigation.
My lord, may I point out 3 lines, my lord?
Please come to Niharika.
Niharika. Where is Niharika?
My learned friend handed over Niharika.
Okay, Niharika. Yes, Niharika. Yes.
Please come to para 33 onwards.
Para 33. 33. Yes.
But I'll take liberty to read.
Please come to 33.2 and 33.6, which is
33.2.
which is against us, which says that it should not thwart any investigation into the cognizable offense and ought not to be scuttled at the initial stage. But please come to para 33.10, which is what we are relying on.
Yes.
Save in exceptional cases where non-interference would result in miscarriage of justice, the court and judicial process should not interfere at the stage of investigation of offences. 33.14.
Yes.
The court has jurisdiction to quash. And now please come to 33.16.
Yes.
Aforesaid parameters will be applicable and or aforesaid aspects are required to be considered by the High Court while passing an interim order in a quashing petition in exercise of 482 or 226. An interim order of stay of investigation during the pendency of the quashing petition can be passed with circumspection. Such an interim order should not be passed routinely, casually, or mechanically. Normally, when the investigation is in progress and the facts are hazy and the entire evidence and material is not before the High Court should restrain itself from passing the interim order of not to arrest or no coercive steps to be adopted. Accused should be relegated to apply for anticipatory bail under 438. High Court shall not and is not justified in passing the order not to arrest and or no coercive steps either during investigation or till the investigation is completed, till the final report charge sheet is filed under 173 while dismissing so and so. Now please come
Yes.
to a judgment of the Honorable Supreme Court passed after Niharika, interpreting Niharika. And that is AP Mahesh Miller. That it should have been pointed out to your lordships.
Then
So first is your lordships have the exercise of being able to stay the investigation even. Please come to AP Mahesh and please come straight away to paragraph 21. Para 22. As rightly pointed out by learned senior counsel appearing for respondents 1 to 3, Niharika certainly allowed space for the High Court to pass an interim order of the nature impugned herein in exceptional cases with caution and circumspection, giving brief reasons. What is frowned upon in Niharika is the tendency of the court to pass blanket, cryptic, laconic, non-speaking orders regarding no coercive steps shall be adopted. In paragraph 60 of the report in Niharika, this court recognized that there may be allegations of abuse of process of law, converting a civil dispute into a criminal dispute with a view to pressurize the accused. In the order impugned in these petitions, the High Court has given elaborate reasons as to how the allegations of bank fraud were developed during the proceedings concerning the allegations of election fraud. Therefore, the impugned order cannot be said to be valid in light of Niharika. So if your lordships come to a prima facie conclusion that a civil case is being converted into a criminal case, that somebody is using the method of criminal justice system to actually coerce somebody else into a settlement, then in those positions, both under Niharika and the relevant paragraph in Niharika is para 16. Please look at Niharika even, as then clarified in AP Mahesh to say that nothing will stop your lordships in the exercise of 482 or 226 to be able to stop this investigation. Please come to para 16.
Yes.
In a given case, there may be allegations of abuse of process of law by converting a civil dispute into a criminal dispute, only with a view to pressurize the accused. Similarly, in a given case, the complaint itself on the face of it can be said to be barred by law. Allegations in the FIR or complaint may not at all disclose the commission of a cognizable offense. In such cases, and in exceptional cases with circumspection, the High Court may stay the further investigation.
Yes.
However, at the same time, there may be a genuine complaint and FIR, and so your lordships, as your lordship says, will maintain the balance. Today, the balance is in the form of an investigative setup. For a person who has not filed a civil case, who has not asked for that 11.72, this FIR is not a means of recovery. He has given a legal notice to me for that recovery, has never acted on it. He has filed an NCLT and then withdrawn that position. In these circumstances, any order for purpose of depositing something prior to even an action being indicated is something which is onerous. Which is why, as I had said in the morning, if they feel that they are legitimately entitled to any amount, let them go to arbitration and do that. As far as the investigation is concerned, investigation must be stayed. This is why this is not a fourth.
Let me answer them.
I got it.
Only 3 lines I want to read. 3 lines, my lord.
Senior privilege.
I have been founder director of this company along with the
34 entry
against me in the entire FIR.
I know, I've seen that.
This case has not been
Their allegations are that these people have cheated me, these people have pressurized me, the investors. Now, why I've been dragged into this criminal case, that is the question mark.
That one just
No allegation against.
that case is not on board. Your lordship will consider.
I know, but
let me answer, Mr. Agarwal.
One last thing, my lord.
One of the directors.
NCLT petition, my lord. NCLT petition, my lord. This is what it is, my lord. The allegation is with regards to forgery, my lord. The allegation with regard to forgery. If I read, my lord, 3 lines from his own petition on affidavit before the NCLT,
He has not said anything.
he's saying I have executed. He agrees to execution. Page 67, last 3 lines. The last thing, he said
60?
Page 67, my lords, last 3 lines. In our petition.
I'll give you the correct number also.
It's para 18 of the petition before the NCLT.
Page 117 of item 49.
49 para?
Page 117
117.
is the relevant page that my learned friend is relying on.
Yes, para 18, my lord.
But they completed their
This
point.
is
of
on
the-
affidavit,
Now,
this is
we-
on NCLT.
People now permit me to reply, Mr. Agarwal.
118.
I will read it.
Yeah, 118. Yes.
I want to say something in this matter. I am the petitioner. I may also be heard for 2 minutes.
118. Huh?
There's 116 at the foot of the page.
116.
Foot of the page.
Yes. Yes.
Thereafter on.
Thereafter, my lord, thereafter,
June.
on 28th June, the share purchase agreement was executed between the respondent number 1 along with the petitioner, that is the complainant, and all the other respondents. He affidavit agrees on affidavit that I have executed this agreement.
Para 19.
What is the end of the
Para 19 also.
para 19 also?
Sir, what is that agreement? Kindly see.
This is before.
1 minute. 1 minute.
Lord, just see the paras 18 and 19. Your lordship.
Section 1 of that proceeding.
Yes, my lord.
Pardon me?
Annex 1 of NCLT proceeding.
Yes.
That's right. The annexures are is the SPA.
SPA. The share
Annexure I.
The share purchase agreement, where they say the forgery has happened. That document.
The one with the.
They referred to.
No, page 99 is the list, is the index.
Annexure 1. He says annexure 1.
Annexure 1.
Yes.
Annexure I. That's annexure I.
I.
That annexure I is also noted by me.
That is
At
page
page 127.
Is the share purchase agreement?
127.
127. And the two pages that our lordship saw, one with that inscription and one without. That your lordship will kindly see as a shareholder, not as a director. That's the point. A director page, you have forged and inserted it. Nowhere is it. Kindly see this, my lord. This is the distinction. No, that is the fraud.
Is on affidavit.
No.
Can I just take a moment, Lord? Can I just take one moment?
Means that in the NCLT proceeding, in the same document.
In his own-
That
Parija sir has shown me.
Kindly
The
see.
same document you say that I have executed.
Yes,
What
sir.
I know.
that document has
In a judicial proceeding.
Yes,
no, we have not filed that. Kindly consider, no, we have not filed that. Signed any
The petitioner there.
Yes, I have a petitioner there. But my document are as to share out. That's the point of investigation.
Going around in
That is the
circle.
point for investigation. Not the director.
I'll pass the order. now. I'll pass the order.
Yes.
Before that, let me reply Mr. Agarwal's submission with regard to judgment. Not your lordship conclude thereafter, my lord. Kindly allow me to reply. Lord, let us not stop at para 33.16 of that Niharika.
Shall I put it tomorrow?
Yes, my lord, you can put it tomorrow.
Put it tomorrow.
Yes, my lord, lordship may put it
Now
tomorrow.
I'll have to go somewhere.
Yes.
Just making one.
Hello, Can I just take one more minute? Can I just take 1 minute, Lord, since my reference?
Yes, Mr. Sutra, you want to say?
Mr. Luthra wants to say something.
My friend, allow me a word. But all I'm saying is, Niharika gets clarified by AP Mahesh Plot. Thereafter, there is a whole series of 3 judges benches, Muhammad Wajid, Abhishek, which have all clarified the law on 482 to say that you have to look at the
All the
FIR
judgment
now
has
minutely
said
to
that
see.
you have to be circumspect
Yes.
by passing an order.
Reasons to be given.
All I'm saying, just a minute, Lord. Niharika, it appeared, basic reading appears to indicate as if it not taught that. AP Mahesh clarifies that position. AP Mahesh in para 25 notes the fact pending of the civil proceedings. In fact, this objection regarding civil proceedings was taken. The same issue was in controversy, and that's the reason the Honorable Supreme Court upheld the order of stay of proceedings, investigation. Now, the issue here will be that the law from Niharika is slowed down. And tomorrow, when your lordship here, after my friend completed, I will also get in 2 words edgeways just to assist your lordship. Not so far as I'm concerned, was that your lordship had, your lordship had given an oral direction to the prosecutor of.
Your lordship close it. We have agreed, my lord. All of us have, we have a consensus. Your lordship may close it.
But that part he's not agreeing. If you agree, I'll put it day after.
I joined the other side. I joined the other side. Your lordships have heard us.
Yes.
Ultimately, my lord, your lordships put something to me which we are constrained to say that we cannot agree. We have given suggestions to your lordships in terms of what ideally could be a balance, which has nothing to do with money. Cooperation is balance. No coercion is balance. That means investigation can go on. but I have to cooperate. This is the real balancing.
Pre-arrest concession is with some condition. What are those conditions? I'm in a 483. I'm putting that question.
I'm placing that as far as the company is concerned. Today, I have already provided, before they have asked me for anything, I have already provided significant material to show that this entire thing is false. Which material, in all honesty, any litigant, like the complainant, should have provided.
Let's not again argue.
The litigant could.
Let's not again argue. Let's not again argue.
As far as I'm concerned, this matter requires a stay of investigation at the interim stage.
So I will not investigate.
If that is not the position,
that's very clear.
If that is not the
Because it has
position,
to be investigated.
Your lordship will protect us.
I just want that you should be protected. That's all. There.
Your lordship think is correct.
I'm focusing. Let the investigation continue. I'll protect some condition. Tomorrow.
Same order he will also.
Same order. Why to again?
Let's see, you have ample document. You have given all these things. I give a direction to the IO to take into consideration all documents. Deal in accordance with law while filing charge sheet or report, whatever.
Or media report, Lord.
It's simple as that. Why unnecessary?
Absolutely correct condition. We agree.
Some condition.
We agree.
What they want, only they have come to the lordship that
See, if the idea is, if they also don't want that, you should go to jail. They are businessmen. You are businessman. He is also business. Something has gone wrong.
Question is in a matter. One last thing, we are a Singapore-based firm, my lord. If your lordship is balancing the order, it may any participation may be through counsel. That's the only request.
I will not control the investigation process. I will not control the investigation process. There is a prerogative of IO. Let him do whatever he wants. I will only protect you so that you see all documentary evidence. All the documentary evidence. You need not come. 161 statement is also not required to be recorded. He will all documents more than enough.
We are obliged.
Look into it and find out what
we are obliged.
Simple as that.
Happen the way it is supposed to happen.
Happen, and all the documents which you have filed here, all the document will be placed before him and it deal with the accordance with.
And tomorrow they will say you didn't call us after the charge sheet is filed. So therefore, let investigation happen.
Your lordships are passing the interim order in those terms.
Interim order, I will dispose of all the petitions.
I'm so sorry. The denial of final relief is something that I would be aggrieved by. This is an interim order.
I will give you liberty if cause of action arose.
I'm so sorry.
After the charge sheet file, you can
respect. Without disrespect, I have the impression that lordships are talking about the interim arrangement.
The problem I tell you, the problem is if these kind of petitions are pending here, there is a constant pressure on the IO who is investigating. Let him have a free and fair
I bow down.
Opportunity of investigating.
For that, your lordships will cross through only one hoop and one hurdle. If the allegation made is balified or is incorrect on the face of it, and that is something.
I'm not closing your way. You have to.
I'm only requesting, Lord, that if your lordships are taking a final view on the matter, please.
I'm not taking any view.
Please consider my
You are requesting, Lord, please keep the matter. Lord, please hear us on the merits. Please hear us on the merits.
I'll record your submission. I'll record your submission, but I'll not take view. Take view either way. I'll record your submission.
That I have pressed.
You file a written note. I'll record. I'll record everything. But I'll leave it to the IO to inquire about it.
That should Mr. Mishra making just one submission because he's on listening.
Can I just say one thing? Lord, our case is really, it's a threshold test, that at the threshold, it's a commercial matter, admittedly, and it's a case of a money claim, if at all, assuming that they have a money claim, though we are disputing it not, and we are shareholders not. Today, we are shareholders in that same entity. Please consider the onerousness and the malified nature of prosecution. It fell from your lordship at the beginning of the hearing. How have they invoked jurisdiction in a place which is none? So kindly look at all these elements. These elements will have to be examined. The IO Lord has chosen to gloss over that aspect. He has chosen to invoke jurisdiction here where he has none. So therefore, we are really concerned. My respectful submission is to your lordship this. Please, I understand your lordship is inclined for an interim, but please place the main matter for consideration, Lord. If we succeed, fine. If we don't succeed, in any case, Lord, will be relegated at the appropriate stage. But at least let us make out a case to say threshold test is bad. We are on a threshold.
Do you want to argue in the matter in your case?
I'm sorry, Lord.
Do you want to again argue the matter?
Lord, I would like to assist your lordship on the main hearing, Lord. Let the matter be finally heard on an interim. My lord may decide, but the main matter will need to be heard. If your lordship is taking a view on the main matter, Lord, I'll need 5 minutes, Lord. I'll just show your lordship. I know today may not be possible.
After the vacation.
Let it be after
Let it be first week of January then.
Yes.
First week of January. 6th January.
Yes, your lordships had indicated to the investigating agency last time. We hope that
I will pass some interim order.
Yes,
Meanwhile, and 6th I'll keep it for 6th.
It's completely
I bow down.
Yes, sir.
Can it be sometime other than 6? I'm so sorry.
Which date? 7th?
We come at 6. But some date other than 6.
7th.
7th, 8th.
8.
Not 8, not 8 is a little, not 7th or 9th, not 8th is a little difficult. 8th, there is a matter which is got listed.
9th Thursday. No problem. 9th, okay.
9th Thursday. Grateful, Lord. Grateful. But that interim, my lord will take care. On the interim,
Interim ought to continue.
Okay.
Thank you. Thank you.
I'm obliged.